Item number 1.
Yes, Mr. Bose.
My lord was pleased to observe that my lord would look into the papers. I have basically made my submissions. There is just one aspect of the matter I would like to make. On the last occasion, my lord was troubled with the fact that even if my lord had jurisdiction, why should my lord exercise that jurisdiction in view of the fact that we have already preferred a second appeal? My lord, it's a question of exercising jurisdiction which your lordship has, or refusing to exercise your lordship's jurisdiction because of the discretion. But to this, my only answer will be, let us assume for the sake of argument, my lord is of the opinion that because of the second appeal, my lord should not enter into the arena of conflict. But the second appeal is from an order of the appellate authority, which said that we should immediately hand back possession and the receiver should go. This is a subsequent order by the regulatory authority, which says that a fine of 5 lakhs should be imposed. Now, your lordship's court today is a court of equity. Even if your lordship does not want to intermeddle with the jurisdiction of the second appeal court, but this question of payment of 5 lakhs should either be stayed, in my humble and respectful submission, considering the facts of the case, or stay suspended till appropriate orders are passed by the Court of Appeal.
Mr. Bose, only 2 things. The order which has been impugned in the writ petition is consequential in nature.
Yes.
The basic order or the main order is subject matter of the second appeal, which is pending before the High Court, but before this court, under Section 58. Now, at the time when this writ petition was filed, the main order or the basic order was operating. That was not made the subject matter of challenge in the writ petition.
Can't be.
So even otherwise, it is there that this court will have to go only into the jurisdictional aspect of that order, the consequential order. Now,
yes,
if the authority has passed an order which has been affirmed up till the first appellate authority's stage, and an appeal therefrom is yet to be carried, when the writ petition was filed, the appeal was not yet filed. At that stage, you cannot say that the authority did not have jurisdiction to pass the consequential order. If jurisdiction, as you know, is an expression of many colors.
yes.
So it did have jurisdiction to pass a consequential order.
Is this in the nature of merely exercising jurisdictional power, or, my lord, executionary power? Since you have not, given possession, therefore you pay 5 lakhs of rupees. It is a sort of a punishment.
The problem is all this can be taken care of by the appellate court. It is not that the appellate court is powerless to deal with this situation.
No, all that I'm saying is, not for a moment am I saying that the appellate court is not, but the appellate court will not be able to deal with this question of 5 lakhs because it's a subsequent order.
Even then, because it's an order passed in execution.
My lord, then the appellate court, then the second appeal will say you first go to the appellate authority, then the appellate authority, if also I fail, then your lordship knows, my lord, this rigmarole is that we invariably have to follow in many cases, where even if I were the other side, I would promptly take that point. But kindly see, my lord, the predicament of the bank.
If the main order itself is under challenge, then in that case, any order flowing from the main order, the appellate court would have jurisdiction. I don't think that there can be any quarrel on that.
I say with respect, it is entirely up to my lord to decide. I say with respect that since my lord today is exercising jurisdiction also as a court of equity, presiding over the writ court, my lord, this 5 lakhs aspect should be stayed in the event my lord feels that my lord will not interfere at all, because propriety demands that the appeal should be heard first. But just one extra point before I round off. Will it kindly see the predicament of the judge? And I dare say this is a very important point and a very practical aspect of the matter, which should weigh with your lordship, my lord, in coming to the conclusion as to whether your lordship should pass any order or interfere at this stage or not. I have given a loan of 6 crores of rupees. Against that loan, my lord, a registered deed of mortgage has been executed. The deed of mortgage contains lists of flats which are unsold and which will remain mortgaged. And the mortgage deed also contains clauses which says that those flats cannot be sold unless the money is routed through the bank and unless a no objection certificate is obtained from me. It is not done. One of those flats which are included in the list of the mortgage deed is sold. Not one, many have been sold. There have been a bogey of applications, litigations, but that is neither here nor there. One of those flats is sold. In the meantime, my lord, they are merely taking away the sale proceeds. They are not repaying the bank. So, my lord, the account becomes sticky. It is declared to be an NPA. When it becomes an NPA account, I take steps in accordance with law under the Securitization Act. I have not done anything illegal. I get an order. They first approach the Debt Recovery Tribunal to vacate that order. Realizing that it may not be possible, then they come to RERA, the regulatory authority. Now, my lord kindly sees a situation has arisen when, without taking into consideration the fact of existence of a prior registered mortgage deed and going into facts like the mortgage deed being executed together with the sale deed, the Court of Rajasthan, which is subsequently upheld by the Supreme Court, my lord, says that in situations of this kind, RERA will not apply. RERA will apply and the SARFAESI Act will not apply, which means the bank is left remediless. How does the bank recover its dues? I can't go to securitization. Under Securitization Act, my lord, I get a receiver appointed. The receiver is asked to return the flat. I can't take any steps for recovery of the money. So an NPA account person, my lord, merrily enjoys the flat, merrily enjoys the money, and ties the bank's hands.
These purchaser of the flat or
Yes.
the home buyer, as they
Yes.
call it, he's not the borrower of the
He's
bank.
not the borrower. Borrower is Ideal Group.
Borrower
Yes,
is
there are parties here. There are parties here.
Yeah,
So, my lord, where does one go? My lord, in a fact situation of this kind, I dare say, and with the deepest of respect, your lordship will be pleased to interfere and at least give some. I understand what is passing through your lordship's mind so far as the second appeal is concerned. But as a court of equity, if my lord feels, if my lord's conscience is in any way, my lord, affected by the flow of events and the law as it stands and the law as it has been espoused, giving a total go-by that I have a prior registered deed of mortgage, should your lordship not interfere? My lord, I had prepared 5 bullet points.
Yes,
if my
that
lord
will
will,
help. That will
if
help.
my lord is
Yes,
pleased
please,
to hand
please,
up,
please.
kindly excuse the last line.
Malad, may I?
Just a minute.
Oh, sorry, Malad.
Just exclude the last line where I asked for written. That's not required.
You can file written notes if you wish to. There's no bar in that.
Then Malad, kindly grant us some time, Malad, this week.
Yes, then we'll
I'll
file
not be
written.
able to keep it beyond 20. I'll have to make it part heard then, and it will be reserved
Keep
for
it part heard. My lord has heard it.
I'll reserve it for judgment. You'll file your written note.
My lord gives us a time, we'll file the written note.
Yes, Mr. Bose, you have completed.
I have not, otherwise I'll be repeating myself.
Malad, before Mr. Chaudhary takes over, Malad, may I just make 2 points, Malad, before he takes over, Malad?
Mr. Bose, is the judgment also that you are relying on? Because on the last day you had handed up 2 judgments, one of that Rajasthan High Court and the other one affirming
These are just bullet points, my lord. If necessary, we should, because I placed before your lordship the Rajasthan High Court judgment, which was relied upon by them, which was upheld by the Supreme Court. Those judgments I've already placed, on the basis of which, and factually we've distinguished. That I did. But as such, I did not place any fresh.
Regarding the jurisdiction of this court, on the point of the alternate remedy.
Oh yes, that alternate
yes,
remedy.
PHR invent.
Yes,
that I have noted.
those are the 3. If anything strikes us, we will. My lord gives us some time. I leave it to my lord. The time is.
I don't find the complainant here. I mean, he has been served, that I have seen from the affidavit of service, but he ought to have been here.
Well, if they are not here, my lord will take note of that. Well, they are enjoying everything, my lord, and it's the bank who's left out in the lurch.
It is stated that the due diligence.
And they haven't even done their due diligence. The deed of mortgage says so. My lord has heard me elaborately on that point. I'll include it.
Malad, may I just make 2 points before Mr. Chaudhary starts, Malad? I think he'll take some time, Malad. Malad, I have only 2 things to say, Malad, if your lordship permits me, Malad. One is, Malad, an interim order cannot travel beyond the final relief if your lordship finds that the final relief would not be entertainable, my lord, then interim orders ought not to flow, my lord. First. Second, my lord, what Mr. Bose was saying that 5 lakhs should be stayed, my lord. My lord, may I just bring it to your lordship's kind notice, my lord, that in the event the main order gets stayed, my lord, in the second appeal, then, my lord, the question of 5 lakhs will also get stayed. Thirdly, my lord, with humility I submit, Mr. Bose has called upon your lordship to adjudicate on the propriety of the execution order, my lord. My lord, your lordship would kindly not go into the merits because, my lord, it has not been called upon before this honorable court, my lord. Your lordship will see that the order is still there. On the basis of that order, was this execution order bad or good? To that extent, my lord. Now, Mr. Bose has already invoked the jurisdiction under section 58, my lord. So, my lord, as I said on the last occasion, my lord, your lordship passes an order. Then, my lord, if the division bench is of a different view, my lord, then that would create a chaos out of cosmos, my lord. With humility, I say this, my lord, because if they hadn't filed any 58, then I could have still understood, my lord. So, my lord, will kindly appreciate that part of the submission of Mr. Bose. And Mr. Bose is repeatedly going into the judgment of the Rajasthan High Court, which has been upheld by the Supreme Court, and trying to distinguish on the facts, my lord. That would not entail, my lord, an alternative remedy point not to be taken, because that is, he's submitting to the jurisdiction saying that the jurisdiction was wrongly, my lord, executed, my lord. So,
No,
under
but-
these sorry, my lord.
Mr. Rai, a mere submission to the jurisdiction would not confer jurisdiction if the authority at the threshold will not have jurisdiction or would not have
Absolutely, my lord. I bow down to your lordship. But
distinction
what I
made by Mr. Bose. He says that RERA itself would apply only if the mortgage is after the event which is complained of. Here in the instant case, mortgage is prior. Subsequent to the mortgage, since the buyer has not done its due diligence, the buyer has purchased a mortgage property.
my lord,
Therefore,
may I say this, my lord, with humility? Your lordship will kindly take the Supreme Court judgment. The only thing what Supreme Court has said, whether the act has come before or the mortgage has come before. If the act has come before, RERA will take over. Only with an exception,
that I have seen.
which, my lord, will be a completely on merits. It will not be a jurisdictional error, my lord. With humility, I say, my lord. It is not a jurisdictional error. I have been allowed to take steps, but if I do not fall within that test, my lord, that would be a factual submission, my lord. So therefore, I say, my lord, with humility, I absolutely bow down to your lordship that yes, submitting to a jurisdiction will obviously not confer jurisdiction. But I have the jurisdiction in view of the Supreme Court having interpreted that if the act comes in before, then I would have jurisdiction, but for that specific, my lord, condition. If it can be shown, then, my lord, it would be not a case of inherent lack of jurisdiction. So therefore, my lord, once he says this, and then he goes into the merits trying to distinguish, my lord, with humility, I say, my lord, that he has to do before the second appellate jurisdiction. My lord, these are my submissions. Your lordship will kindly grant me whatever time your lordship wants for the written notes. I can do it within 2 days also if your lordship directs me.
Okay.
My lord, may I take your lordship's kind leave, my lord? Your lordship will kindly.
Somebody there for
Sorry.
the
Yes, Mr. Shah is there, my lord. I'm so sorry, my lord. I'll kindly excuse me, my lord.
Yes, Mr.
Milord,
Chaudhary.
I'll be very brief. Milord, first
He was
issue.
appearing for mega resources. I
Yes.
was under the impression he was appearing for somebody else.
No, no, mega resources. I am the petitioner who's approached RERA.
Therefore, the complainant is here.
Yes, yes.
Oh, that's it. That's fine.
I didn't want to interrupt, Mr. Milord, kindly see the grounds. Milord.
Actually, then there is a wrong recording in the order. It has been recorded as respondent number 1. Actually, Mr. Bose, the cost title is also not, that has caused the confusion actually. The cost title is also not correctly the array of parties. Private respondents have been
Yes.
separately
Yes.
numbered.
My lord will name them, my lord. That's the mistake.
Kindly correct that, because then in that case I'll grant leave to correct the serial
We
numbers.
make it 1, 2, 3, 4.
You make it continuous. It will be
Yes.
4 and 5. Then this
Yes.
confusion will not be there. Mr. Jishnu Chaudhary for respondent number 1, he'll be for respondent number 5.
Yes,
I'll grant leave, please correct it today.
we will.
Yes, Mr. Chaudhary.
My lord, first, my lord, principle is that this is an order in execution, really. My lord, if the main order, my lord, stays, my lord, the dependent order or the executing order would also, my lord, have to be given effect to. Main order is up in appeal before the second appellate court. Yesterday, the appeal appeared. There was some defect. My lord, I was not there, but I am told that numbering, etc., was under consideration. It will be listed, my lord, next week. Second. 1st of April. So, my lord, that's so all grounds which are to be taken attacking the order in the second appeal are only to be urged there and are not to be urged here. I take my learned friend's argument, my lord, that please consider the order in execution in isolation. So, my lord, I'll take that a step further. I'll assume for the
It will
moment,
be listed on the 1st of April.
yes.
That's very near, Mr. Bose.
Yes, but it's from the other order.
All the more
That
reason
is
for
the other order.
That-
My lord will deal with it in the way my lord deems it fit and proper.
So, my lord, I'll just make my submissions this way. So even if I accept, my lord, without going
Yes,
into,
perhaps I know what is passing through your lordship's mind, whether we should adjourn this matter till the 5th of April or something.
yes.
I don't mind, my lord.
But it's not my submission.
Then I also appreciate, my lord, if they want the issue to be tested, because it's a new area
Yes.
of law. So I appreciate if Mr. Bose says that I want the matter to be decided in writ jurisdiction. I am ready for it. There's no difficulty. But if your lordship keeps it, my lord, on the 5th,
We'll come
we can
back.
come back on the 5th.
We'll
If
come
that
back on the
order
writ.
goes, then, my lord, this
Then
will
the writ
also
goes.
go.
If the second appeal is not admitted, then that will be good ground for me to not entertain the writ petition.
And even if the second appeal is admitted, I'm sure they can ask for a stay there and get that matter stayed. It should be one matter. But I leave it to Mr. Bose. If he agrees, we can come back on the 5th.
Yes, yes, we can come back because I waited.
This I can tell your lordship.
We'll come back with the written notes, but my lord will grant us leave, but adjourn it. Depending on what happens in the second appeal, we'll come and
But
tell
this
your
much I
lordship.
can assure Mr. Bose. If, my lord, the main order is stayed in the second appeal, I will consent either there or here, wherever he chooses, for this order also to be stayed.
Very well.
Automatic.
That's very gracious of you.
Even if there is no prayer, because that is what propriety demands.
Correct. Absolutely correct.
But if it is not stayed, then I will, my lord, pray for dismissal of this writ petition.
But then all the submissions which I've made will revive.
Yes,
Definitely.
automatically.
There will be no fetter on the.
The 5th is a Saturday, my lord.
The
Maybe
next
come
week
on the
then.
7th, my lord, if your lordship permits us.
But then I'll not be able to fix it on any day because I have jurisdiction only till the 28th of this month.
My lord, it can
This
be.
determination is only till 28th. Thereafter, I don't know. I may be.
But let it be marked as part heard. We'll come and mention one
I have no
particular
objection.
day. My lord,
Unnecessarily, why will I mark parted? Because I don't know before whom it will go.
my lord has heard it's.
I agreed, my lord. On our joint request, it can be done.
Kindly make it part heard. And it won't be very long because we will know our
In any
fate.
case, before anybody, it won't be long. I would have loved to decide it, but since this appeal is on the 1st,
Well, we would have also loved your lordship to decide it.
but then since it is on the 1st, even propriety won't demand me taking this and deciding it in
My lord,
a haste.
first, if the main order is stayed, all of this will also
All
be
of this
stayed.
goes.
My lord, keep it for the time being. My lord can always let go of the part heard depending on what happens on the 1st. We will
Or if
both.
your lordship doesn't want to mark it part heard, your lordship can reserve judgment and we'll come and inform your lordship on the 2nd as to what has happened on the 1st. But then your lordship wouldn't want to keep a matter CAV
Yes, for long.
indefinitely.
I'm adjourning it then simply.
But as part heard, but again, we will have to
Mr. Bose,
start
there
it
is a
over.
provision you can mention, get it assigned, saying that matter was if both of you agree,
Yes.
instead of me making it part heard. That can be done. If the parties substantially agree,
Every
that
violation
Suggestion to Board. The hearing is almost concluded. Then
My
we
lord,
use
my lord,
that
this is
order
just a suggestion, respectful suggestion. My lord can say hearing is almost concluded. The matter will appear on the day this bench sits next.
I have no objection to anything.
Or the hearing is concluded. Let the matter appear on the day this bench is available to sit singly.
no, but I'll have to mention this 1st April thing, because that is the reason for me to
Yes.
postpone
Yes, say
it.
so. This hearing is, for all practical purposes, it is concluded.
Really, my lord, it's infractuous today. If on the first
Yes.
he gets a stay, my lord, I'll agree to a stay there itself, even though this is not directly under challenge.
Technical hurdle.
And if
we
he
have to
doesn't
solve.
get a stay, I'll pray for dismissal. And that itself is the ground for dismissal, that the main order has not been interfered. And if your lordship looks at the grounds,
The reason why I'm asking for it parted, it's been fixed on the 1st of April. We are facing a technical problem there, not because of our fault. Whether it should be FMAT or SMAT and in brackets RERA, because of there are judgments by Justice Harish Tandon.
yes,
So we really don't.
And
My lord keeps it parted, my lord. That's the easiest way out.
part heard, I don't want to keep.
Hearing almost.
Then my lord says hearing concluded.
That I'll record.
Leave may be given to correct it. not to
Ah,
correct the
But kindly
cost
grant us leave to correct the cause
item.
title
Yes, yes.
And to the written.
and file written notes of arguments,
Yes,
whatever
I
be
will.
the fate.
The matter was listed under the heading for orders today. Full stop.
my lord.
However, Mr. Bose, learned senior counsel appearing for the writ petitioner, Mr. Rai, the learned government pleader, and Mr. Chaudhary, the learned senior counsel appearing for the
Should be respondent number 4.
for Mega Resources Limited. For Mega Resources Limited, have made further submissions. Full stop. Hearing is concluded. Full stop. At the juncture of conclusion of the hearing, this court has been informed by the parties that an appeal has been preferred. The appeal that had been preferred has been preferred against the appeal under section 58 of RERA that has been preferred against the order dated September 20, 2024, passed by the West Bengal Real Estate Appellate Tribunal in WBRE 80 appeal number 010/2024. Had been listed before the division bench on
1st of April.
no, had been listed when last
Yesterday, my lord, it was there.
had been listed on Calcutta date the full stop, and that full stop now, and that the same has been directed to be listed again for admission or for hearing admission on April 1, 2025. Full stop. Since the order impugned in the present writ petition is in the nature of a consequential order, aimed at implementing the order dated June 24, 2024, passed by the West Bengal Real Estate Regulatory Authority, within brackets, which got affirmed by the order dated September 2024 by the Appellate Tribunal, comma, it would not be proper for this court to decide the writ petition at the present juncture, full stop. The writ petition, the hearing of the writ, since the hearing of the writ petition has already been concluded, that has been recorded. Let the writ petition, the parties are given liberty. Okay, then the parties are given liberty to mention this writ petition upon the conclusion of the admission hearing of the pending appeal. You have a number of the appeal, or you don't have?
SAT.
SAT
25 of 20.
25 of 2025.
SAT 25, 22, কোথাও এক জায়গায় ঢুকিয়ে দেবেন, তাহলেই হবে।
My lord, kindly grant us the liberty to file written submissions, notes of arguments also before your lordship.
All parties.
Parties request for leave to file written notes of arguments. Such leave is granted.
And liberty to
Within-
mention is already there.
Liberties to mention is already there.
Great.
Will it be my lord's pleasure to mention a date within which such written notes are?
Before you mention anytime.
Very well.
Grateful, man.
কি সব বলে দিল? পারছো, এখনই করে দিয়েছে। Well, the correction has already been.
Leave is granted, ekdom topic, to the learned advocate on record for the writ petitioner to correct the serial numbers of the array of respondents
In course of today.
In course of
the
today.
day. In course of the day.
1, 2, 3, 4, 1 is serially going down. I'm very grateful to my lord.
না আমি on record নই।
আপনি জিজ্ঞেস করছেন, আমি করে দেবো না।
হ্যাঁ, করতে পারবে না। On record বলতে সই করতে পারবে না।
ওটা এর ভেতরে আছে। স্যাট হাইকোর্টে আছে, ওটা অ্যাপিলেট ট্রিবিউনালে আছে।
Item number 2. Number 3.
Well, I'm for the respondent. This is the third occasion the petition is not coming.
It's a broken bench.
And you're right.
Dismiss it.
And I submit my lord that this is not even a group 9 matter. That I pointed out yesterday, my lordship. Because the filling of the pukur and all the
He is not a
Let it be. I am making it not today again. If they don't appear, they don't appear, because unnecessarily I'll not dismiss for. It's a broken bench.
They are coming, my lord.
will not make it go out to the list, my lord. Then if he, my lord,
Of the list or dismiss what you are, they will make restoration application. This could be there. Don't you realize our difficulty?
What is your difficulty, sir, in appearing before the court?
No. My lord.
Then
In the morning, my lord, this item 2 or 3, so my lord, your lordship needs to see the other court.
very well, I'll not dismiss it. Let's proceed. Next.
My lord is making note today. Number 6.
For the petition, on the last petition, we were on a point that whether this petition can be heard by your lordship sitting in the determination of group 9. Lordship, I have gone through all the law, the field, lordship, and I spoke to my learned senior friend also. So far, I agree regarding the things that there is the bench which is taking up the group 1 determination and now passing these orders. But so far, the question of law is concerned, lordship. I should apprise your lordship on this.
করতে চাইছি
There is
কি
the
করতে চাই না
decision of the division bench where the point was taken up. The point was there the bench having determination of group 1 had passed an order for removal of the encroachment from the highways. Nayanjali is considered to be the part of the highways under the State Highways Act 1964. Now, Lordship, there this matter went up to the appeal on the ground that the in appeal the point was this matter should have been heard by the bench having the determination of group 9. Now, Honorable Justice Boshak, the division bench comprised of Justice Boshak and Justice Sabbar Rashidi has held in one paragraph, Lordship, I will be reading, that encroachment is to a land belonging to the government and the encroachment has to be removed. The land may come under the definition of the highway under the Act of 1964, or it may be beyond such definition and may be governed by a different statute for eviction. Essentially, in all statutes of eviction of unauthorized occupiers of the government property, it is an immovable property, that is, land which is involved. In short, encroachers are required to be removed from land belonging to the state. Land is an essential component. The writ rules have classified different types of writ proceedings into 9 several categories for the sake of administrative convenience. Group 1 has classified matters
Mr.
related to
Chatterjee,
land laws.
why do you want to go into all this?
Lordship, I'm leaving it upon your lordship. If your lordship want to hear, I want to say your lordship may pass an order on this. But apart from that, if your lordships
I have a sample copy of the order that has been passed. It would end it to my
for this
friend's
particular
benefit.
lordship, I
If he doesn't want
but
that,
I wanted, so it's my duty to
say a procedure has been laid
there
down
can
by
be
Justice
some
Roy.
cases where this overlapping
Same
may happen.
thing.
But order was
A
ultimately
proceeding
held.
under Section 10 of the Highways Act is to be effected and nothing else. That is to
I
be
am
given by.
making it simply not this week. That will help. Unnecessarily it will go out, then again
Yes,
come
তুই
in.
ওটাকে ওখানে mention কর হয়ে যাবে।
Huh.
I will do, but unless your lordship releases the matter,
No, I'll not be required to release it because it is only till 28th. My determination is only
Fine.
till
No, one
28th.
thing a lordship can do, if a lordship permits him to change the that form, the group, inadvertent mistake, that will inure to his benefit. He can go and mention there. Perhaps there will not be any assignment or something like that.
that
But then again, it has to go out of the list.
that's
No, if a lordship gives him the leave, his advocate general is going to correct the group in spite of the group 9 লিখেছিস তো।
group 9.
So in spite of that, he will write and put a
Very well.
signature.
Take it.
That will inure to his benefit and he can directly go there and mention it.
Then I'll have to record consent of both the parties.
Yes.
Otherwise, I have to decide this whether it is group
Yes,
9
yes.
or
আবার এইসব ঝামেলা করিস না, ছেড়ে দে।
it is submitted.
ও তো মামলাটা নিয়ে কথা তখন
It is submitted by the parties that the matter pertains to group 1. Full stop. Leave is prayed as prayed for. Leave is granted to correct the classification description in the presentation form. Full stop. Let the matter be released from this list and be placed before the appropriate bench having determination.
But রিলিফ কথাটা হলে আবার অ্যাসাইন করাতে হবে না তো? Let it go this or something like that.
This before the appropriate thing.
রিলিজ করে দিলে কি হবে, আবার তোকে অ্যাসাইন করা যায়, কথাটা ইজ ডেঞ্জারাস ফর ইউ।
To matter to we'll have to release the matter. How can I retain it in the list then? That has to be released.
Normally it has to be released.
Has to be. That is why I said that
Yes.
instead of going into all that, not this week would have helped. Because
After that your lordship.
Because that format will be remaining, the form.
so what? He'll take leave there and get it done because this is a
That
broken bench.
Lordship, that would be better, lordship.
আবার তোকে ওখানে না গ্রুপ 9 এ গিয়ে তোকে চেঞ্জ করাতে হবে, সেটা বুঝতে
Release
পারছিস
না
না?
করে go out of list করবি. Let the matter go out of list and be placed before the appropriate bench having determined.
Great, sir.
আমি তো দোকানে পাচ্ছি না, অর্ডার করেছিল, আমরা কি করবো, ভুল জায়গায় করলে।
Number 8.
এই তো
Madam, for the 8.
Respondent number 7.
My lord, I'm for the private respondent, respondent number 7, Mr. Parthapratim Rai is appearing in this matter, my lord. My lord, he has been instructed, he has instructed me to pray to fix this matter at 2 p.m. if my lord pleases, my lord.
Why not today?
My lord, son.
Why not today? Instead of 2 p.m., have it done, then do it tomorrow.
My lord, much obliged, my lord.
Not today.
My lord.
The remaining in the list. Number 9. Ten.
When do you pay for the West Bengal Pollution Control Board?
My affidavit of service. Your lordship, this is in connection with the demolition of the Mandarmuni beach resource. Your lordships, you know that there are several matters filed. Apart from that, the Mandarmuni Hoteliers Association also filed a writ petition, and that is we said the orders passed in that writ.
We are challenging an order passed by the National Green Tribunal.
Lordship, apart from that, there is an order passed subsequently. That is the after passing of this, after filing of this writ petition, may I be permitted to file the supplementary affidavit, wherein it has been directed to demolish the construction. That
but
is the
is
subject
there,
matter.
is there there is a provision for appeal, isn't it?
There is also your lordship. I have handed over the orders of the past by the.
May I just clarify that legal position? Plus, Section 22 is the appeal provided under the National Green Tribunals Act. Now, my lord, to be candid with your lordship, my lord, initially an order was passed by the Honorable Supreme Court. I do not have the citations with me right now, saying that, my lord, ultimately it was held by that since, my lord, 226 is the basic structure of the Constitution, so therefore writ will also always lie.
That is always that.
If it is an appeal, it will go. So thereafter, my lord, the writ petitions have been entertained by by your lordship, time and again before this court.
No, but it has to fall within the bracket that yes, it is something which is
Amenable to writ.
Amenable to writ jurisdiction, public law element is involved,
Yes,
and
of course.
iris of an act.
This is basic.
And
As per the-
several writs has been filed with regard to this cause of action. Similar nature of notice has been issued, and your lordships, I have handed over the orders passed by the several orders has been the India stay order has been passed, and apart from that, on the last occasion, it has been inquired that whether this hotel is the part of the association, which is the writ petitioner in 27403 of 2024, and I have inquired that they are the part of the association.
But nothing has been given to that. No document.
Lordship, I have the documents right with me. So I think, my lord, this will be tagged with the that writ petition. That is the.
I'm not standing in it. That's a question of law.
Why should it not be in the
A notice was under challenge in this.
Lordship.
Not an order passed by the
Notice. The notice has been is under
order
challenge.
was initially in the writ petition, the order passed by the London National Green Tribunal was challenged.
State over the supplementary affidavit, your lordships will find at page number 14. A notice has been issued that to demolish on 11th November 2024 to demolish. That is the subject matter of writ petition in that is the cause of action. For every hotel.
Where is the order passed by the NGT?
At page 173, if your lordship, my lord, kindly, I'll tell your lordship the operative part. Lordship kindly comes to
209.
yes.
The operative portion starts. And it continues till page number.
Paragraphs 19 to 21 at page 209 and 210. Paragraphs, basically paragraphs 19 and 20, 19 to 21.
Okay. It was the same order under which this notification was
Lordship,
also issued.
Lordship, Lordship. That is under the challenge before the in WPF 27403 of 2024.
What is the CRZ notification?
Well, the CRZ notification is the coastal regulation zone notification. Well, delineating issued by the central government, delineating well, the high tide lines. Not from the high tide line until what distance? Well, they are
Yes.
classified as zone 1, category 1A, 1B. But depending on the categories, the range of the nature of constructions are either completely prohibited or partly allowed. That is the CRZ notification. But initially, firstly issued, if I remember correctly, in 1991. Subsequently thereafter. Right, 91 or 2011. NDZ is no development zone.
Only one thing I would like to submit to correction. That only the application, I mean the petitioner has not annexed anywhere that whether they have the consent to operate or not. That I only the application is there. I have the illegible copy of the annexure of the application. The annexure P4. So whether what is the fate of that application, that nowhere has been disclosed, whether they have the consent to operate or not. That is also the requirement under the central.
We have given the same copy so many times.
Lordship.
What?
No, your Lordships.
Yes. I thought there are several orders.
Several orders are passed. Say
There is
all
one
the
order
orders.
and
Oh, that's some
that's
orders has gone. Your Lordships. There are 5 orders perhaps. Your Lordships.
These are all extensions.
Lords,
One order.
I have
Main order is one.
everything I have given. What is the present status also?
How do you say that your case falls within the 4 corners of this order?
Lordship, there is an Lordship, may I?
Yes. Please.
On the basis of the Green Bench judgment, your Lordship, these steps has been taken. All the hotels has been given the same notice, and we have appeared before the concerned authority, and the same order. I should not say this is an order because there is no reason. Your Lordship, kindly see page number 14 of my supplementary affidavit.
No. The supplementary affidavit is a consequential order as a
Consequential order.
main order. How is the main order faulted by you?
Lordship.
How is the main order faulted?
Main order is that, your Lordships, that I have been not made a party over there, number 1. Number 2, your Lordships, there was no specific zone has been declared till date, so far as my knowledge goes.
Mr. Bihani.
But the declaration of zone depends on the West Bengal Coastal Zonal Management Authority. Lordship will find from that is the state government undertaking. I do not declare it. As far as she was submitting, my lord, the consent to operate, that is my purview. That I will take
Has he been
instruction.
given the consent to
For
operate?
that I have to take instructions. We do not know because he was on a different point altogether, challenging the order of the learned tribunal.
If he doesn't have the consent to operate,
But if an unit doesn't have a consent to operate, then my lord, whether the another bench is hearing it, given a stay, or the entire purview goes. If he doesn't have, if unit doesn't have a consent to operate, he cannot operate. That is, my lord, universal, whatever the unit may be. But that I'll take instructions. But he was on the point. He was telling me just now that the similar orders have been passed. That I'm not. I'll take instruction on the consent to operate. If he doesn't have it, he cannot till he gets it. That I will take instruction.
because he has to demonstrate also that his case falls within the four
That's
corners
right.
of the same.
That's right.
What is his case, and how is it similar to the case in which stay has been granted?
Lordship, মন্দারমণি, your lordship, ওই আমার কিছু জাজমেন্ট চলে গেছে।
এই যে দিয়ে দিন।
Lordship, may I be? Your lordships kindly take up the order dated 22nd November 2024. The third paragraph. The notice dated 11 November 2024. That
I've
is
seen that. I've seen that.
lordship. Issued by the chairman district level committee. That is there. All stakeholders.
Hmm.
I am also falling under the same. Lordship, may I be permitted to hand over I have taken the instruction whether I am a member of the Mandarmuni Beach Hoteliers Welfare Association or not. I have taken the instruction. It is there.
No, but why have we not annexed it with the writ petition?
Lordship,
Because this
at
was
that
a
point of
pertinent
time,
question.
afterwards,
cropped up.
afterwards it has been
If
filed.
you are trying to take advantage of this order,
Then
you
I
have
have
to
to-
show that you are
Lordship, then I have to come with a supplement again.
file a supplement.
Lordship.
Because this writ was filed earlier than this one.
That's why that is the difficult.
But in the supplementary affidavit, you also could have-
You could have brought this on record by way of the
It was
supplementary.
subsequent to that.
Oh.
It was subsequent to that.
No, your membership is subsequent
No,
to that.
no.
Then
The writ has been filed by the Hoteliers Association subsequent to the
to your writ.
affirmation. Absolutely, Your Lordship.
Your writ is prior in point of
Prior.
time.
Apart, my supplementary affidavit which has been handed over to you has been shown earlier.
No.
Your Lordship.
Very well. Can you file it by tomorrow? Then I'll keep it tomorrow.
Lordship, tomorrow I have some difficulty. If Your Lordships kindly take it up after the 3rd of
Then you
April.
take back this supplementary, file a composite supplementary, unnecessarily why will you?
Lordship.
No, this is not like the earlier case where Lordship has heard it substantially. As has fallen. This is not. No. Very well. We would have loved to come back to your Lordship.
As prayed for,
Lordship, kindly keep it up to 3rd of April, Your Lordship.
I'll give you a week's time, you find. Leave is granted to the writ petitioner to file a supplementary affidavit, bringing on record these are what subsequent events,
Lordship, subsequent events as well as the
bringing on record the notice dated 11th November 2024 issued
by the district level committee.
notice dated 11th November 2024 issued by the district level chairman, district level committee of WBC-ZMA and district magistrate and collector Purvo Medinipur. Along with the document saying that
Secretary of Planning.
the petitioner is a member of the Mandarmuni Hoteliers Association.
Member Secretary.
Full stop. তার উপরে লিখে দিন. The writ petitioner is aggrieved by একদম উপরে লিখুন. The writ petitioner is aggrieved by an order dated 22nd May or 2nd May. Order dated
2nd May, Your Lordship.
2nd May 2022, passed in OA number 134 of 2015 by the National Green Tribunal, Eastern Zone.
Okay.
Full stop. It is submitted on behalf of the petitioner that this court has entertained a writ petition being WPA number 27403 of 2024, within brackets, Mandarmani Hoteliers Association versus Union of India and others, against the same order, and has granted an interim order staying operation of a notice of demolition issued on the basis of the said order. Full stop. A notice dated 11th of November 2024 is also sought to be brought on record. I'm taking this on record. Is also sought to be brought on record by the writ petitioner by way of a supplementary affidavit saying that the writ petitioner is also aggrieved by the said notice and that the writ petitioner could not bring the said notice on record earlier as the same was issued subsequent to the filing of the writ petition, right? Paragraph. It is further submitted on behalf of the writ petitioner that the writ petitioner has in its possession a document to evince that the writ petitioner is a member of the Mandarmani Hoteliers Association. Full stop. He seeks leave of this court to bring such document on record by way of a supplementary affidavit. Such leave is granted. The writ petitioner may file such supplementary affidavit within a week from date.
10 days. I will be not able.
Within 10 days from date. Full stop. Copy thereof shall be served upon the respondents. Liberty to mention.
এটা দিয়ে দিই। এটা দিয়ে দিই। এটা নিয়ে নিই। 12 দিয়ে দিও, নাম দিয়ে দিও। নামটা দিয়ে দাও। I have Lord respond number 7. Lord Lord
Petitioner.
petitioner is not here.
Time for the response number 10, no copy has been served. I
The
paid
petitioner is also not here. It is
Direction
broken
Not
bench.
this week. In order to avail me Lord the positive instructions, I am the answering respondent in this one. Lord, can you adjourn for a week?
Only 2 more days. Let us see. They come tomorrow.
My lord, item number 12. I'm praying for not this week, my lord.
Or you are praying for not this week, not this week.
no copy has been served upon the
Serve
response
a
number
copy.
10.
12 number
But this petition became infectious. Why I'm telling Lord?
You just sought for instructions. Now you're saying it has become infectious.
This is the instruction Lord.
But you said you don't have instructions.
Lord, the overfull. This is written instruction is listed.
Then wait for your turn.
Yes, Lord, this is. Service for 13. নামগুলো দিয়ে
Tomorrow if they don't come, I'll start dismissing it from tomorrow. যেগুলো adjourned হয়েছে না এগুলো সব একটা for dismissal এর heading উপরে করে দেব পরের দিন।
15. Number 16. Maya.
Lord, this is my affidavit of service.
Who is for the respondent?
Lord, it is the drug control authority. State, only state of this name.
Serve a further notice on this government pleader.
Government pleader.
লিখে নিন একটা order record করুন. Affidavit of service filed today is kept on record. It's taken on record. None appears for the respondents despite service. Full stop. The petitioner shall serve another notice on the respondents, informing them that the matter shall be taken up again on Friday,
Friday month.
28th.
Well, in this matter, my lord, I paid for my lord the written inquiry by the GM, that is page 64. Allegation against my lord the respondent number 5, that is the private parties hearing. Regarding my lord, they are alleged disturbing to the my lord, regarding the plot of land, as well as the my lord, that they are using some languages which has been my lord inquired into. Police authority has already started an FIR. My lord, each has been my lord looked into by the district magistrate, then it will be my lord the better for the petitioner. Well, otherwise, this lady is a widow lady. I mean, he is allegedly disturbing so that my petitioner cannot stay in his dwelling house. So, mass petition as well as the complaint has been done, then come to page 64 straight away.
Page?
Page 64.
Yes. What is this?
Page 64 মানে মাননীয় জেলা শাসক জেলা হুগলি মহাশয় আপনাকে জানাইছি যে শ্রীমতী লিপিকা দে, that is a complaint as a prosecution Kuntola, this is a private.
But under what provision will the district magistrate under what provision will he inquire?
My lord, I have been inquired asked for my lord the regarding if it is considered under the my lord the Senior Citizen Act, I have not, but these private parties, my lord, he is a senior citizen and widow lady. And if inquired, my lord, the process of my lord the administrative level, my lord, the district magistrate is also the holding the post of the administrative level. My lord, the police has my lord the already my lord inquired into the.
You serve the respondents again. We again order tag to kore din. It will appear on Friday.
Friday.
Serve a notice again on the respondents.
Service is kept on record.
Affidavit of service file, please.
18.
I'm for the petitioner, Your Lordship, led by Mr. Bhani, Union of India. Yes. Lordship, my client took a loan from bank and the due amount was rupees 10,02,887. Now accounts become NPA in May 31, 2021. Now the matter went to Lok Adalat. Lok Adalat passed an order which is at page 21. Lordship kindly comes once. And the settlement amount was 3 lakhs. Point B, Your Lordship. Page 21, annexure P1.
Page 21.
3. Settlement amount was 3 lakhs. Now there was 3 installments were provided to me. And Lordship kindly comes to clause E, which is important here. That they will issue me the closure certificate within 15 days after the disbursement of the last payment. Now, Your Lordship, after that, I made payment in 2 installments and the last payment date was October 7, 2023. Till date, no closure notice, no closure certificate has been given to me. After that, I sent a lawyer's notice that is on annexure P3, page
Page 23.
23. That is on 5th March 2024.
Yes, madam.
Till date,
Why
nothing
are
has
you
been
not
done.
giving him the no liability, no dues certificate?
Your Lordship, I don't have any instruction, Your Lordship.
Why?
Even they have
Take
acknowledged
instructions,
also.
come back on Friday. You have to give it. The borrower has squared off the dues in terms of the Lok Adalat's award.
Lordship,
There is a settlement reached.
Well, I'm sorry to interrupt. I'll only point out one thing. But later take instructions. But kindly comes to page 22 once. Lord, you have seen the
Yes, yes,
Lok Adalat's order?
I've
My lord,
seen this
kindly
also.
I have paid it earlier. Now,
Yes.
kindly sees what they say. Above matter is pending with somebody. As soon as we received any clarification, also they want a clarification. They were after my business is stopped. I cannot run my truck. I have to come to your lordship's court spending my money
Back on
because
Friday,
of
you have to give the no dues certificate. Order at record.
this.
The writ petitioner is aggrieved by the non-issuance of the no dues within inverted commas no dues or within inverted commas no liability or our within inverted commas closure certificate by the bank to the writ petitioner despite the writ petitioner squaring off the bank's dues in terms of the award of the Lok Adalat.
The affidavit of service.
Full stop. From the award of the Lok Adalat. What is the date of the award?
September 9, 20.
September 9.
5.
September 5.
My lord, some clarifications there, my lord. I'm appearing, she is appearing actually, my lord, for Union of India. The bank officials is the, my lord, the answering respondent here. And we have no.
The bank.
Bank, my lord, I don't know, my lord, who is the bank, my lord.
September 9,
Bank
2024.
No. Oh, me,
Union. Very well. You serve a notice on the bank, it's there only. Just
No, we have
across the
served
road,
earlier
Red Cross
also. We'll
Place.
wait him.
Serve a notice personally. I'm
Not.
fixing it day after tomorrow.
Not.
Uh,
My lord,
the award of the Lok Adalat.
well, may I make a submission? But I have been informed by the advocate, learned advocate, and record that possibly they had sought to serve the bank personally. My lord, some officer of the bank has said that no, we will not receive. So my lord kindly puts in a line that if the notice is served by the advocate record, they will receive it. Otherwise, lord will hear it ex parte. Refuse করেছে বলেছে নেবো না
What did we write? The award of the Lok Adalat. A copy of the award of the Lok Adalat held on 9th of September 2023 has been annexed to the writ petition at page 21 thereof. Full stop. The writ petitioner points out that the amount settled to be paid by the petitioner borrower for squaring of the bank's dues was to the tune of rupees 3 lakh. Full stop. This quote is taken through a letter dated February 28, 2024, issued by the respondent number 4, wherefrom it appears that the writ petitioners have paid the settled sum of rupees 3 lakh to the bank, and yet the no dues certificate has not been issued by the bank on the ground that, within inverted comma, matter is pending with all caps, with the all caps CGTMSE with inverted comma closed, full stop. It is not understood as to why should the certificate of should the no dues certificate be withheld by the bank upon the borrower paying off the settled sum, full stop. The bank is remains unrepresented despite service. No, but it's personal service.
This was served at the time of the filing of the writ. So at the time of mentioning it was again sought to be reserved, then my lord, they did not.
The bank remains unrepresented despite service, full stop. As a last chance to the bank, the writ petitioner, as a last chance to the bank is given one more opportunity to appear before this court and explain why the no dues certificate should not be given, should not be issued in favor of the writ petitioner, full stop. A notice to this effect would be served upon the bank by the writ petitioner, full stop. The matter will appear before this court on Friday.
Friday, some difficulties, মানে সোমবার করো।
না না থাকবে না ফ্রাইডে অবধি আছে আচ্ছা কিছু বলার নেই আবার সোমবার But I have barged in because I wanted to appear with your lordship.
Much obliged, my lord.
Thank you.
আটা যদি ডিটারমিনেশন আছে
I am for the respondent, my lord.
Not today. All these matters will appear one day for dismissal. All these matters where they are not appearing. One day, maybe tomorrow. I'll club all those matters.
Yes,
They will
because
appear
they
for
have,
dismissal.
this matter also appeared yesterday, they did not.
See.
Grateful, man. 20.
Lordship, I am appear on behalf of the state.
For the
My lord.
petitioner, lordship, I am praying for 1 week time.
Not today. Not this week.
Thank you, lordship. 21.
I am for the petitioner, my lord. I have served, my lord. This is my affidavit of service, my lord. My lord, LIC is the respondent authority, my lord. My lord, claim, my lord, the petitioner is the holder of the LIC policy, my lord. Petitioner accident was done, my lord. And when a report was submitted, the claim was made by the mother of the policy holder, my lord. But they have given as a normal award, my lord. Not a kindly see the reason order, my lord. Rejected the accidental claim, my lord. Kindly see
I think
page
there is a
24.
provision for appeal.
Yes, my lord.
There is a provision for appeal against an order of rejection of claim.
Kindly see the page 24, my lord.
That I've seen.
Yes, my lord.
But I think there is a provision for appeal against the order of rejection of claim. Please find out.
Yes, my lord. Then my 7 days time be granted, my lord.
Not this week.
Deeply appraised, my lord. No, affidavit is service kept in record, my
No,
lord.
no, you take it back.
No. 22. Thirty. 31. 32.
My lord, 32 and 33, my lord, I am praying for only not today, my lord.
Not today.
32 and 33.
32 and 33.
34.
Lordship, I am for the petition. I have served, my lord.
The learned advocates for the opposite parties were appearing, were there yesterday. Affidavit of service.
My lord, I'm appearing on behalf of the respondent in this matter. I'm being led by senior counsel Mr. Ratnanko Banerjee. My lord, kindly pass us over the matter.
Well, in that case, my lord, I have got a supplementary affidavit. If my lord so deems fit and proper, I'll serve the supplementary on them here and now, and my lord may pass it over for tomorrow. My lord. It is taken up. They can also go deliberate on the supplementary affidavit so that the matter.
Order referred for in. Director.
My lord, I'm filing the supplementary.
The
Thank you.
Mr. Trivedi, the learned senior advocate appearing for the writ petitioner, seeks leave of this court to file a supplementary affidavit in connection with the writ petition. Full stop. Such leave is granted, and the supplementary affidavit filed today is taken on record. A copy of the supplementary affidavit filed today has also been served upon the learned advocate appearing for the. You are appearing for all the respondents.
Yes, my lord.
Appearing for the respondents.
Are you appearing for Union of India also? I don't. Well, there is something.
No.
Because Union of India
Lord,
is
I'm only
a party here. It is actually my allegations against Standard Chartered Bank, whom I suppose she is representing.
My lord, I'm appearing for Standard Chartered Bank.
That's
You are appearing for respondent number 6.
My lord, 6 and 7, if I'm not mistaken. My lord will allow me, my lord. Lordship, I apologize. My lord, it's not 6 and 7, Lordship.
6 to 10.
Lordship. It's 6 to 10, Lordship.
6 to 10, madam. 6 to 10.
6 to 10.
My lord, kindly allow me a minute. Kindly allow me a minute.
Please take your time. For Standard Chartered Bank, na?
And Lordship, Reserve Bank is 32445. In fact, my lord, my reliefs are against Reserve Bank and against Standard Chartered Bank. I have leveled allegations against them. And I'm just wanting, my lord, my consideration of my representation under 35A, which the Reserve Bank is entitled to.
The affidavit of service filed today is kept on record. Respondent number, the respondent appearing for Standard Chartered Bank hoega Lord. The other respondents are not represented despite service. Full stop. The matter will appear for further consideration tomorrow. Madam.
My lord. My lord.
Tomorrow.
I'm grateful.
Grateful, my lord.
My lord.
$35.
35, Mala, I'm for the petition. What happened, Mala, in the year 1991? Mala, in the year 1991, Mala, around some, including Mala, the 90s, Mala, some documents Mala registered before the in the sub-registry office of Mala, the West Purva Medinipur. Mala, the document, the stamp paper used were found to be forged, alleged to be forged, fraudulent stamp paper used, while registration has been made. For initially, that was during at the time of registration that was not detected. Subsequently, it has been detected. The registration has not been completed. That kept pending. The petition, it was not known to the petitioner since petitioners purchased the stamp paper from the stamp vendor and used the same while according to my lord the normal procedure. The registration has been not been completed. My lord, that's why my lord, the petitioner, as and when my lord applied for certified copy, that was not supplied. Several registration was made such in such way. My lord, the dispute cropped up. My lord, one petition was moved. My lord, initially that petition was dismissed. My lord, subsequently an appeal was preferred. My lord, the appeal court, my lord, granted leave. My lord, that is my lord. That has order has been my lord, the appeal court's order has been my lord, the court out my lord, in another writ application on page 31 my lord, my lord's brief. Where my lord, appeal courts my lord directed the my lord, the registering authorities to accept the my lord, the amount of stamp duty, the amount charges of stamp duties, and my lord, the directed them the my lord, the may I place the my lord order. If my lord, I made the payment, my lord, equal to my lord, stamp duty, and my lord, within certain period, my lord, then my lord, the registering authority will consider my lord, the registration and allow me to my lord, obtain certified copy as per my lord, normal procedure application on the basis of application. And subsequently, if my lord, after one adjudication it is found the stamp paper is forged, then the amount would be utilized by the state exchequers. Otherwise, my lord, the amount which was deposited, which would be deposited, that would be refunded to the my lord petitioner. That's the direction of the my lord previous.
Yes, ma'am.
Original document has been seized by the DEO Mohishadol, my lord. Then the same has not been returned to us, my lord. But my lord, we can give certified copy to the party, my lord. If they deposit the stamp duty deficit stamp, my lord, we can give you if your lordship directs, my lord.
As one of passed in the court in range in the other application, my lord.
If your lordship directs, my lord, we can give, my lord. As party have to.
You have any instruction to that regard?
Yes, my lord. My lord, written instruction. But my lord, this is the SOF, my lord. That's why, my lord.
Very well. Yes, ma'am.
The last paragraph, my lord.
Right. Please take down. The writ petitioner. Now, the writ petition has been filed seeking issuance of a writ of mandamus on the respondent numbers 3 and 4 to deliver certified copy of 2 registered sale deeds in respect of plot numbers 88 and 87 by 3548, comma, Patian number 2564 and 2732, comma, JL number 126, comma, measuring 15 decimals under Mouza Basudevpur, comma, PS Durga Chowk, district Purbo Medinipur, being deed numbers 2120 and 2122, dated April 3, 1991, under IGR space F hyphen 356716 and 356718 to the writ petitioner. Full stop. It has been submitted by the writ petitioner that the said property, the subject property, the property which is subject matter of the said deeds, properties which are subject matters of the said deeds were registered upon compliance with all formalities, including payment of statutory stamp duty and registration charges. Yet the respondent number 4 has not discharged his statutory duty to supply the registered sale deed to the petitioner. Full stop. It has been submitted that full stop. Ms. Such and such appearing for the state submits that the certified copy of the said deeds could not be made available to the writ petitioner since the said two deeds, the original deeds had been seized by the capitals D full stop E full stop O Mohishadol, and that the same have not been returned till date. Full stop. It has been further submitted that the certified copies of the documents can be given to the party if necessary directions are passed in such regard upon the party depositing the deficit amount of stamp duty. Full stop. In response thereto, the learned advocate for the writ petitioner invites the attention of the court to an order dated April 24, 2013, passed in WP number 9809 within brackets W of 2013 by this court, wherein upon relying upon a division bench judgment of this
36.
My lord, I beg to appear for the petitioner, my lord. My lord, I was seeking some time to file an affirm. It has not been affirmed, my lord, a supplementary affidavit to bring on record certain new facts, my lord.
My lord, may I make my submission? I'm appearing for respondent numbers 1 and 2, Banking Ombudsman and Reserve Bank of India. My lord, the writ petition has become infructuous because if your lordship kindly looks into prayer B at page number 24 of the petition, what has been sought for is for a mandamus commanding the respondent number 1, that is my client, at page number 24, if your lordship will turn to prayer number B.
Yes.
Mandamus commanding the respondent number 1 to hear out the said
And dispose
complaint.
of the that has been
Yes,
done.
we
My lord, I have something to say, my lord. In this regard, my lord, we have not been given any hearing, my lord. An order has been passed, and there are certain other facts, my lord, which needs to be brought on record, my lord, for effective adjudication, my lord.
is this and my
Kindly
respective
grant me.
If an order has been passed,
Yes, and
you
was
can always-
communicated also.
Always,
My lord, there is some.
Yes.
My lord, there is also some malafide in this, my lord, because they had not on the first occasion, my lord.
I'll observe that all of this will give you a fresh cause of action.
My lord, kindly give me some time, my lord. My senior will satisfy your lordship in what why this.
My lord, the order was communicated on 12th of December 2024. We had
It's long,
closed
sir.
the
You should have
complaint.
been ready with the supplementary affidavit.
My lord, there was no instruction from the client, my lord, for that reason, my lord.
Then your
Kindly
client-
grant me an accommodation, my lord, so that I can bring.
Necessarily will you keep this dead matter pending? We are
Time.
required
My
to
lord, there is
complete
something,
it, no?
my lord, there is something which needs to be brought on record, my lord.
Should have been brought on record. It's if
That's
in
a-
December we have already lost 3 months.
My lord,
You will
and my
get
lord,
a-
in regard to my lord, if we take into consideration, my lord, the banking ombudsman scheme, my lord, clause 14 of the scheme, my lord, talks about various aspects which has not been taken into consideration while disposing of this application.
That will give you a fresh cause of action. You can challenge the
I bow down, my lord.
fresh writ petition.
I-
But we have a supplementary affidavit. You will not be able to enlarge the scope of this writ
But
petition.
still, my lord, there is something because we have in our prayer we have categorically mentioned that respondent number one has to hear out the said complaint, my lord. There was no hearing, my lord.
My lord,
We have
first and
not been given
foremost,
any hearing, my lord.
giving of
That gives you an opportunity to challenge it.
My lord, I am satisfied your lordship, my lord. Kindly grants me some time to affirm the supplementary affidavit.
the purpose of the writ, they are trying to enlarge the scope of the writ. My lord
My
has
lord, I will
rightly
satisfy your
pointed out,
lordship, my lord.
as has fallen from your lordship, my lord will also look into it because there are
My lord,
umpteen
clause 14 of the.
Let me complete my submission.
Please.
Now, so far as the complaints are concerned, before the banking ombudsman, number of complaints are lodged. Now, whether on prima facie, whether a complaint is maintainable or not, at the threshold, a decision is taken at times, like in the instant case which has been done, because it is purely a private dispute, a dispute between the petitioner and his brother, who is the private respondent number 5.
My lord, then kindly
Because
take
I'll just indicate briefly on the facts also, there is nothing with regard to the top up loan which has been taken by his brother, the petitioner's brother, who is the respondent number 5. Certain documents were sought for by the concerned bank. Those documents are not being provided by the brother, that is the respondent number 5, on account of which bank said that bank wrote to the petitioner and said you supply the necessary documents without which we cannot progress, and otherwise your EMI would be outstanding and your account would be declared as NPA. So on the basis of that, the bank has taken steps. There is no lapse on the part of the bank.
That the top-up loan which was taken, my lord, it was taken suppressing material facts, my lord. The petitioner was misled not just the brother, my lord, even the bank officials sent the petitioner certain pre-drafted mails and asked him to send the mails through email, my lord. My lord, so my lord, I'm kindly seeking some time, my lord, to bring on record certain subsequent facts, my
Your
lord.
writ petition was filed at a time when your complaint by the ombudsman had not yet been taken for hearing. Today, we are at a stage where the ombudsman has disposed of your complaint. You are now required to be aggrieved by or you are definitely aggrieved by the order passed by the ombudsman. So you have to mention your grounds on which you are aggrieved by the order of the ombudsman. How in this writ petition?
My lord, I bow down, my lord. Kindly grants me a day's time, my lord.
What purpose will it serve?
My lord, my senior will, my lord, come before your lordship and satisfy your lordship.
Come tomorrow. Bring
Some time, my lord, some time. Only some time.
Day after tomorrow.
My lord. Or maybe sometime, my lord, so that I can. 1 or 2 or 3 days, my lord. Some time is needed, my lord, to get this thing affirmed, my lord. There was no instruction from the client, my lord, sir.
I leave it to your lordship. I'll not stand in the way, but the prayers are very clear. No prayer is.
একটা order record করে নিন।
Kindly.
The
one person, namely Amit Gupta. He was arrested by one GST intelligence authority, that is DGGI Jamshedpur. And thereafter his property was attached. During the course of attachment, Amit Gupta sold out the property. And myself, my locus is that I was an employee of Amit Gupta. And this Amit Gupta, what he did, he carried on all its business rather, in my name without informing me by using my all identity, all KYCs. And now the issue is, if this Amit Gupta can escape from this situation, I will travel, my lord. That is the reason I have filed this petition. I have, my lord, Kanya before your lordship for the cancellation of the deed, which he has transferred during the period of attachment, my lord. Page below that. My lord, come to my
Have you served all the respondents?
Yes, yes, yes.
You are appearing for?
State respondent, state of West Bengal. I'm not Mr. Raushi Basu that
Ah, very well.
Thermal page? Page 29. Page 29 is the attachment order, my lord. And we have informed the registry officer also that it has happened.
There are so many respondents, but the service is only on 2 persons.
Yes, my lord. It is on. It is to state and to DGI.
Now, what about the other respondents? You've made them parties. Axis Bank, IIFCL,
Axis Bank.
IIFL.
Yes, they are the banker. So I have added them as party. If required, then we'll make the
All of them. Why, if you have added them as party, then in that case you must have added them because they might have a say in the matter, right? You cannot proceed against them without serving them.
The IFL and ICICI Bank, I do want to proceed against them. They are the financer.
Delete their names. Because if you keep them in the array of parties, you'll have to serve them. If you don't want to proceed against them, delete their names. You cannot keep them on record and then not serve them.
Okay, my lord, it can be recorded. Rather, I am expecting all these parties then.
What is your prayer? Against whom have you sought the prayers?
My prayer is against the registry office, my lord. Cancel the deed.
And what is the ground for cancellation?
Ground for cancellation is it has been transferred during the period of attachment. The property is still attached.
Transferred by whom?
Transferred by Amit Gupta.
Amit Gupta is also a party.
Amit Gupta is also a party.
Has he been served?
He was served. Amit Gupta was served, right?
No, he is also not served. He is a necessary party.
Okay, my lord, I will serve them.
Service.
Complete service.
From the affidavit of service filed today, it appears that all the parties, all the respondents have not been served. Serve all of them.
Okay, my lord.
All the respondents have not been served. Full stop. In fact, one of the necessary parties namely the respondent number 7, who would be impacted by any order passed on the writ petition, has also not been served. The writ petitioner is therefore directed to serve the respondent numbers. You are appearing for the state.
State of West Bengal.
State means respondent numbers 1 and 2.
So I do not have.
Yes, my lord. Yes.
Is directed to serve all the respondents afresh and file an affidavit of service on the next date of hearing. Liberty to mention.
My lord, in that case, my lord, there is a subsequent fact as well. So can I defer our supplementary affidavit also?
The writ petitioner ওটা আমরা ঢুকিয়ে দেবো এক জায়গায়। The writ petitioner further submits that that there are certain subsequent events which are required to be brought on record.
Advance copy will be served.
By way of a supplementary affidavit, and he seeks leave of this court to file a supplementary affidavit bringing on record such subsequent events. Full stop. Leave as prayed for is granted. Full stop. Let such supplementary affidavit be filed within a week from date.
My lord.
A copy of the same shall be served on all the respondents. Liberty to mention upon completion of service.
Both the petition and the supplementary affidavit, my lord.
ওই মার্চ করে দেবো সার্ভিস জিনিসটা মার্চ করে এলে আমি এডিট করে
কপি আছে
tomorrow, not this week.
I'm for the state, my lord.
Not this week.
Not this week.
দেবেন
এতদিনে মামলা 24 থেকে
I am for the petitioner.
I am for the respondent number 6 and 7, Your Lordship. Private respondents.
My lord, the petitioner is the owner of premises number 122 Kalighat Road, my lord.
Where is the other respondent, CSC?
My lord, I have served, my lord. They have received.
They have served, but they are required. Without them, how will I hear? Not today, come tomorrow.
Tomorrow,
It will appear tomorrow.
my lord.
Obliged, Your Lordship. Obliged.
$51.
Your Lordship, I am for the petitioner's lordship, Your Lordship. The matter for the wife was driven by his husband and he is staying in his father's house. And as a consequence, he is making a complaint before the police for the proper action, but he is not taking. But this time the wife is residing in his matrimonial house and the partner is already served complaint.
What is your submission? It has become infructuous.
Yes, Lordship.
You don't want to proceed.
Yes, Lordship.
You have a written instruction.
No, I have no.
You bring a written instruction. I will record it and I will dismiss it.
All right, Lordship.
Tomorrow?
Yes, Lordship. Tomorrow.
It will appear as to be mentioned at the top tomorrow.
Yes, Lordship.
Bring your written instruction and withdraw.
Yes, Lordship.
$53. $54.
I am reading on behalf of the respondent.
I'm for the petition.
I'm for the respondent number
54.
laid by Mr. Anand Banerjee in this matter, my lord.
Lordship, this matter relating to disbursement of prize, lottery prize money. As the petitioner has purchased the lottery and Lordship, this lottery have been selected for winning prize money. And Lordship, this payment has not been disbursed.
All the respondents have been served.
Lordship, kindly consider the affidavit service.
Madam, you are appearing for respondent numbers?
I am appearing on behalf of the respondent number 4, 4, 6, 8.
4, 6, so not 5. Acha, you are appearing for state.
Authority has not been represented. The state of West Bengal.
No, 1 and 2 he is appearing, is it?
He is not the state of West Bengal. That is the state of Nagaland. The lottery is for the state of Nagaland.
You are appearing for only 1 and 2 or 1, 2 and 3.
Yes, yes, 112.
So you are appearing for 1, 2 and 3. You are appearing for 4.
6, 8.
You are appearing for 4, 6 and 8.
Only the
And
district
7, you are appearing for 7 also. Nagaland state lotteries, 7 also. 7 you are appearing. So 5 nobody is appearing.
and the state
9,
respond.
10, 11 state respondents. Who are necessary parties here?
Also, the Nagaland is the next.
State is not required.
It's not the, but all this monitored by the district magistrate. So district magistrate I have met him.
Your grievance is against the Nagaland authorities.
Nagaland authorities as well as future.
That is, I am representing.
That is who has issued the future gaming and hotel services private limited.
And what is the respondent number 5? My agency.
This is also issuance of the authority under Nagaland.
No, no.
No,
My
so this
agency
is the
in
local agency.
Birbhum.
Sorry, this is a local agency who has sold this lottery. This is a private authority.
679. My agency has been served. Mr. Banerjee is appearing for 4 and 6.
4, 6 and 8.
So state is not represented, my agency is not represented. Yes.
Now, Lordship, these 4 petitioners, Lordship, purchased the lottery which was selected for winning prizes. Now, Lordship, initially I moved a writ petition before this Honorable High Court. Lordship, this is during the pandemic period. Now, Lordship, kindly come page 142.
143.
142 is the starting order of this Honorable Court.
Yes.
Now, Lordship, it was directed that if such original tickets are produced before the respondent number 4, upon being satisfied of the authority of such tickets, the respondent number 4 is directed to act in accordance with law and disburse the lottery. Now, Lordship, what happened? We have, Lordship, communicated this letter, but during the pendency of the pandemic, my client could not. It was delayed. Kindly come page 145. Admittedly, we could not comply the order within a period of 1 month. That is the. Now, Lordship, we communicated the order and Lordship, we expressed our willing that we are seeking to produce the original tickets in connection with the above mentioned writ petition, that is page 146. Now, Lordship, they have written a letter. Kindly come the Future Plus Enterprise, page 155.
Page 155.
The writ petition, paragraph number 1.
155, yes.
The writ petition being WPA number has been disposed of by the Honorable Justice such and such.
Yes, I have got it. Yes.
Now, in view, now the paragraph 2.
I have read it. I have read it.
Now, Lordship, they have refused to accept this original because I could not submit the same within a period of 1 month. Then, Lordship, kindly come page 158. This is my another submission of the letters that I am ready and willing to original tickets to all authorities. An application for disbursement of lottery winning prizes in terms of the result sheets published at the instance of the authorities upon production of the original lottery along with 50% banking interest. Now, this is our representation. Now, also today I am praying for, let's say my original tickets is with me. Let there be a direction to certain period and time and place. Let's say we produce the original tickets upon issuing the, let's say the seizure list, and let's say let the prize money, whatever they according to them, prize money be disbursed in my favor.
Yes, Mr. Banerjee.
Lord, in my humble submission, the petition is not maintainable because the claim is now time barred. 3 years is the limitation for a money claim. It's basically a money claim for money. Now, 2016 is the date of the lottery being declared and him becoming the successful as per him, because till date we have not seen the originals. So we don't know whether Xerox copy anybody can have. He'll have to produce, till date he has not produced the original. Now he's claiming that he has it. In any case, my lord, 2016, my lord, is the starting point of limitation. He filed a consumer dispute, my lord. That was rejected by saying that you are not a consumer. After that, he waited for some time and filed the writ petition in 2017. And March 21, the order was passed by the Honorable Court. From that also, my lord, now 4 years have elapsed. Even if the, my lord, benefit of COVID is for 1 year is taken, my lord, in my humble submission, the entire period, my lord, takes him beyond the period of 3 years. Even if, my lord, that COVID period is deducted. 16, then 1 year, 17, the writ petition, 21, the order. So it's a time barred claim. Secondly, my lord, this Honorable Court has directed, entertained the writ petition, given a specific direction. Now, if he fails to, my lord, comply with that, he should have not paid for, my lord, extension of that time before the same court. He has not paid for that also. So on these two counts, my lord, in my humble submission, at this stage, my lord, he cannot come and maintain a writ petition. Because it was his fault, my lord, not to produce the original. In any case, my lord, he was at fault because unless he produces the original, he cannot, my lord, claim the prize. He has never produced. Now he was asked to produce, he has failed that also. So kindly consider, my lord, whether it is maintainable at all or not, my lord. And since, my lord, I am only, my lord, the distributor, these are lotteries being conducted by the, my lord, organizing states. Here it is the state of Nagaland. The organizing state, my lord, the claim is basically against the organizing state because the state conducts the lottery, which is the organizing state, and the host state is West Bengal. We are the mere distributor of the, my lord, organizing state. But today, my lord, the claim against us is not maintainable.
Yes, Mr. Mukherjee, why did you approach the court late?
Lordship, kindly come page 95. Lordship, my clients were not sitting idle.
Page 95.
Yes, immediately, Lordship, 95, I have filed an application before the district redressal forum.
That you have done, but
Yes,
what is your explanation after the order passed by this court in 2021?
Kindly come this, I have immediately filed an application that I am willing to produce this original lottery tickets. That is, Lordship, the representation at page 145.
Page 145 is 1 year after the order.
Yes, because at the relevant point of time, COVID period is running.
COVID ended in
deciding in the
COVID extension ended in February 28, 2022. The window closed thereafter 90 days, which ended in May 2022.
Now, lots of
so COVID you will not be able to take advantage of because you had approached this court in COVID.
No, 13th May I have filed an application. That is page 145.
Thereafter.
Now 13th May they have refused to Lordship that they they have refused not only that I have not the original with me. They have refused that I have not.
They have refused in 2022 only.
No, they have refused on 23rd May 22. I have submitted application 13th May 22.
10 days.
10 days. Now, Lordship, they have refused only what ground? The ground is that I could not produce the lottery, original lottery within a period of 1 month from the date of the order of the Honorable High Court.
Very well. So even after 23rd May 2022, your approach is in 24. 2 years.
Now this
This refusal gives you a fresh cause of action. This refusal on 23rd of May 2022 gives you a fresh cause of action.
I have the original ticket. The purpose is that produce his original tickets and they will disburse the money. If I unable to produce the original,
But why have you not been able to do it all this time? All these days you have not been able to do it. Even in terms of the order, you did not do. What is your explanation why you could not do it? What is your explanation in the letter? 13th May 2022.
Lordship,
you have not mentioned any reason.
Yes, I have. Lordship, kindly. No, I have filed an application also. Also, subsequently, one application was filed before the learned, the Honorable Court, who passed the order.
Where?
That extension of time.
Now, where is that application?
I have mentioned also in this.
What happened to that application?
The application is pending.
Then how are you filing this writ petition? It's already there. Can 1 of 2022,
Yes,
which is
I filed
pending.
an application for extension.
So move that this writ petition is not maintainable there.
No, writ petition on the basis of, Lordship, my further application, that is at page 158. And I have challenged their refusal order because their intention is to see the original ticket. That is with me. Lordship, I will produce the original ticket. They will, Lordship,
on the face of the specific direction that it has to be produced within a specific time, my lord.
That was the period.
On the face of that, subsequent approach is not maintainable. He has to, my lord, either get
period of COVID.
And not the date of declaration of lottery is 16th of November
Money
2015.
automatically disbursed to me.
16th November 2015 is the date of declaration. So, my lord, simple arithmetical calculation, my lord, takes it beyond 3 years. It's a money claim. It is nothing more than a money claim. He could have filed a suit also.
Duty, because I am holding the winning ticket. They have not disbursed the winning ticket in spite of my repeated
Mr. Banerjee, will the state be right in taking the point of maintainability? I am taking the point of limitation.
No, I am the distributor, my lord. I can take. I can take.
My lord comes to page 119. That is the order of the learned consumer court. Not maintainable.
119.
119. My lord, just above 4 paras above the ordered portion. But in the present case, the OP number 1, that is the state of Nagaland, by filing a petition on 22nd of April 2016, prayed for directing the complainant to go to the office of Future Plus Enterprise with original tickets for disposal of the matter. The prayer was allowed. That's in 2016. Order dated 2017. Today, my lord, we are in 2025. There was a specific direction upon the petitioner. They could have produced that original at that point of time. The prayer was allowed.
But kindly consider one thing, my lord. It is the duty of the state to pay upon production of originals. If somebody slips over his right, doesn't produce the original, in that case, no, now he's saying I'm ready, but he has not produced. Admittedly, that is not his case made out. That is not the case made out in the representation. He says now I can produce. So he has slipped over his
Can you produce within 1 week?
Yes, within 1 week.
Let them have
within 48 hours. Let's say everything was me. Let's say let him
fix
the date. I will produce all
that original is there or not. And Lordship will kindly consider this point because it is a pure point of law. That it is a money claim. He could have filed the suit against the state or the distributor for this same relief. This honorable court entertained because in some cases if it is admitted facts, it could entertain. But now, my lord, it has gone one step further. Not only it's a money claim, but it is a time-barred money claim. Kindly, my lord, consider that. Whether at this stage it can be entertained or not. Previous round, it was within the timeline. Honorable court has entertained. But
there was no COVID.
But still 2021 order was
it was entertained. So that period he will get benefit of section 14. He will get benefit of section 14 for 17 to 21. I am not on that. But not excluding that also and the COVID also, my lord, he is beyond 3 years. So now there are two prongs of attack, my lord. Not only a money claim can be entertained by writ courts. Then long line of judgments can be entertained if it is admitted money claim. But so far as, my lord, the other point of limitation, my lord, it's a pure question of law, whether he can maintain it, either suit court or writ court. Kindly consider that. I'll not come back with a, let him come with the originals, because I am in doubt whether he has the originals or not. Let him come back. But don't close the issue, my lord. I'll come back with a calculation. If I can show from the date of declaration 16 November, it is not time barred, then, my lord, it is time barred for all purposes. I'll make the calculation.
You also bring the original. Let us have it on Friday then.
Friday, my lord.
Heard learned advocates appearing for the respective parties. Full stop. अच्छा affidavit of service law ऊपर ही लिखे लेना.
But sir, I have annexed the.
Just a minute. There is no representation on behalf of the respondent number 5, 9 and 10, despite nine and 10 with Toner Namta Toner Chakravarti. Mr. Chakravarti, give your name.
I am for the petition.
I'm
Yes.
for the state respondent.
Yes.
The petitioner is a legal here. The inherited property. And we, my lord, the suit has been filed. The interim order has been passed. The private respondent, my lord, started a construction, unauthorized construction, encroaching the road of the PWD and also my portion of the land. Well, I have made a complaint, my lord, page. At page 43.
Page
43.
Huh.
43 para 2, my lord, I have said so. Your lordship kindly come to page para 2 of the 44. Starting from 43, but
you want consideration of this complaint? You want this complaint to be considered by the authority? I'm disposing it off by directing you to consider.
Yes, Lord.
The affidavit of where is the affidavit of service? Affidavit of service filed today we kept with the records. Full stop. The writ petitioner is aggrieved by non-consideration of his representation made. Who will consider?
The item number 34, Your Lordship, in today's matter, Lordship, it was called, Your Lordship, I am the advocate on record for the respondent number 6 to 10, Your Lordship. Lordship, my junior appear
tomorrow.
Lordship, one humble indulgence, Your Lordship, in that matter, Lordship. Today, writ petitioners has filed one supplementary affidavit, Your Lordship. Lordship, no prior service was given to us, Your Lordship. The matter was running in the list for last 2 days. Thereafter, also, they did not make any prior service to us, Your Lordship. Lordship, my humble submission is, Lordship is granted, I understand, a leave to file the supplementary affidavit. Lordship will kindly record my objection to the supplementary affidavit, Your Lordship, because they are bringing on record two substantial documents which was never there, made part of it, which was not served upon me, Your Lordship, and I am being taken by surprise, Your Lordship. Lordship will
You will be given an opportunity to have your say on that. I have not passed any order. Dealing with the supplementary affidavit, those documents have only been allowed to be brought on record. They have been brought on record.
Lordship.
Matter is not yet heard. Matter will appear for hearing tomorrow. A copy thereof has been served upon a London.
Yes, Your Lordship.
You say whatever you have to say against the documents. I may accept it, I may not accept it. The supplementary affidavit is just taken on record.
It's just kept on record, Your Lordship. That is all I bow down, Your Lordship. It just kept on record. It's not accepted.
No.
I'm deeply obliged, Lordship.
The writ is yet to be admitted.
Yes, Your Lordship, because we are challenging the maintainability also, Lordship. I'm deeply obliged, Lordship. I'm deeply obliged.
My lord.
My lord, I beg to appear for the petitioner, my lord. May it please your lordship, my lord. My lord, there are three matters, my lord. One, I missed the matter, my lord. One, I missed the bus in the morning, item 30, my lord. What I'm praying, my lord, that
Can
is
appear tomorrow.
my lord, let these matters be taken on Monday, my lord, because they have affected fresh service, my lord. I just
Monday,
filed
so then it has to wait. I'll make it not this week because I will not have determination for listing it on Monday.
Monday, my lord. Then on Friday, my lord.
Friday it can appear.
My lord. On Friday, all the three matters, my lord.
Three means which one?
30, 56 and 86. My lord, 56,
30,
86, similar matter. 30, 56 and 86, my lord.
30, 56 and
86, my lord.
86.
Yes, my lord. This is same financial matter, my lord. Kulam Mandalam. 56 and 86. 30 and 86, I'm sorry.
30, 56 and 86.
86, my lord.
All three will appear on Friday.
I'm grateful, my lord.
Date दिए थे मैंने आपको नीचे.
57, my lord, I beg to appear on petition. Now, the petitioner before your lordship participated in a selection process for the post of assistant primary teacher. He qualified in the state examination. He was called for an interview. According to petitioner, he did fairly well, but his name was not included in the panel. He made an application in 2024 under the Right to Information Act, which appears at page 13, my lord. With certain queries that was not replied, then first appeal was carried out. But I am before your lordship seeking a direction upon the authority to provide the information that has been sought for. The remedy that
But
I
there is
have,
a provision for appeal
my lord,
before the
I do
commission.
appreciate, but that takes 2-3 years to get a hearing before the second
But
appellate
you could have
authority.
filed an appeal and you could have approached if the authorities.
The very innocuous prayer that was made. If your lordship kindly turns to page 13, the information that has been sought for.
The appellate authority has not disposed of.
No.
That also
That
is a
appears
ground for appeal.
Yes. Page
If you
16,
don't-
first appeal.
If you don't get the answer to the appeal, that also is a ground for appeal before the commission.
Yes, my lord. I do appreciate, my lord. My lord is correctly pointed out. The thing is that
The state has been served.
yes, my lord, I think state has been served.
What about 2 and 3? The government pleader may not be appearing for the appellate authority.
Yes, ma'am. First appellate authority.
They need to be served.
Or may I serve and come back? It does not appear to be that
No, it has not been served.
it has not been served.
Since service is incomplete, the writ petitioner is directed to serve the respondents afresh. Liberty to mention after completion of service.
Much obliged.
And for the petitioner, Lord.
I appear for the respondent number 4 and 5, my lord.
People still.
All the respondents are appearing.
Respondent number 2 is from here. Respondent number 2 would be the actual.
Respondent number 2 and 3 have all have been served.
Yes, copy has been served. And
Affidavit of service. Affidavit of service.
So it is not available with me today because I expected that it will come on tomorrow because it was the 58 serial number. That's why I expect.
Tomorrow you will be able to bring it.
Definitely. Sir,
Not today.
please fix it day after tomorrow.
Friday.
Friday.
Wait, my lord.
Normally, 59.
I appear for the private respondent.
Petitioner.
59, I'm praying for a day's adjournment, Your Lord.
Not today.
Wait.
Would I appear for the respondent number 5?
Okay, for the respondent.
Petitioner.
Okay, Your Lord. Extremely unfortunate writ petition. Private information of a particular lady, my lord, has been sought for.
Very well. Petitioner is not here. Let us see.
Very well, my lord.
Passed over.
Sixty-one.
61, I am for the petitioner. Your Lordship kindly turns to page 24. My lord, we are living in a civilized society. Your Lordship kindly sees what is the situation. Page 24. This is what has been done by a club, and my only way to ingress and egress to my property. And this is what I am facing. There is order. I will place all these ordered by the subdivisional magistrate to remove this before the police authority. Now, they all are sitting hand in gloves.
Have you served all the respondents?
All the respondents.
Affidavit of service.
Now your Lordship kindly turns to page 32. I approach before the concerned subdivisional magistrate. There is a direction upon the police. Your Lordship kindly turns to page 32, my lord.
Just a minute, let me see the service once.
Service is completed. I've seen.
Yes, page.
Page 32, my lord. My lord, I approached before the Consul Subdivisional Court. My lord, your lordship kindly sees fourth paragraph. The petitioner has presently prayed before this court that the only way for ingress and egress has been blocked. Considering this, OC such and such police station is instructed to ensure that the ingress and egress of the petitioner is not hampered in any way till the matter is.
Yes, I've seen it.
Yes. Now, my lord, police has also, my lord, police went there, conducted an inquiry. Your lordship kindly sees page 35, the type copy. The original report is at page 34. সরজনীন তদন্তের সময় স্থানীয় বাসিন্দাদের বক্তব্যে জানা গেল যে সাচ এন্ড সাচ দাগ নাম্বারে সাচ এন্ড সাচ আবার খতিয়ান নাম্বার রেকর্ডে দখলে আছে। উক্ত জায়গার সম্মুখভাগে বাদী পক্ষের মন্দির ঘেঁষে যাওয়া আসার গ্রিল গেট আছে। এটি যাতায়াতের গেটের সামনে বিবাদী পক্ষের প্রাচীর দিয়ে আটকানো আছে। So it is admitted position by the authority also that in my malad, in front of my gate, they erected a boundary wall on the government land and blocked it. And your lordship will see from page 24, it is absolutely in a temporary measure, only to make inconvenience for me. The Mandir committee wants the adjacent land to be donated in their name.
But how will the writ court decide all this?
Well, this is public inconvenience and the construction is on the government land. This is public inconvenience. SDO is under the obligation to remove all nuisance under section 133 of Code of Criminal Procedure.
What has
Now,
the SDO done?
Malad,
What has the SDO done?
SDO had done nothing. Malad, the order passed by in the capacity of magisterial capacity, SDAM, your lordship kindly sees page 31, subdivisional executive magistrate. He has only passed the order. Who will execute it? Malad, I'm putting this question to myself. Who will execute it? Who will make the malad, remove the inconvenience for me?
Sub notice on the state, come back on Friday.
Friday আমাদের তো ইয়ে আছে না? ক্যালেন্ডারটা বার কর, ক্যালেন্ডারটা বার করে।
Or you can come tomorrow.
Yes, malad, tomorrow, perhaps malad, within
today you can serve the government pleader and come tomorrow, or on Friday if you want.
Malad, I will come tomorrow. Tomorrow to হবে। tomorrow. Malad, tomorrow.
Serve a notice.
Malad.
To লিখেন into. None appears for respondents despite service. Full stop.
হয়ে যাবে।
May I please your lordship?
Service.
Service complete, my lord.
You've seen
Service complete, my lord, only the state respondent. But my lord, here, my lord, the point what I candidly submit, my lord, state, it will be better to take up the writ petition in presence of the state, since it is in gist, may I say?
one more notice. I'll take up
And
tomorrow.
my lord, day after tomorrow, if I can get state government office of the government leader has been served. But let me try it, get hold of the state advocate and come back. My lord, what I was also listening eagerly to the proceedings of this bench, my lord. But this, what I may humbly submit, my lord, these things, the matters which are being returnable on Friday, my lord, including this matter, maybe some heading, so that otherwise in CIS it will be again on the serial.
No. It will be at the top where orders have been passed. Those matters will be at the top.
Maybe separated under a separate heading and some precedence, my lord.
Because those matters are fixed on Friday. The matters which have been fixed on Friday will appear at the top only. Order passed by এটাতে সেগুলো না যেগুলো হ্যাঁ will appear on Friday. Serve one more notice.
Without with lordship
আগের অর্ডারটা এখানে রেকর্ড করে দিন, শুধু লিখে দিন despite service none appears for this.
before other and my lord, before other matters, my lord. Deeply obliged, my lord, deeply.
Thank you.
My lord, I appear for the petition. This is the affidavit of service. Now, my lord, the petitioner's wife was admitted to a hospital for the purpose of a delivery. Now, there was a consent form wherein the signature of the petitioner ought to have been there with regard to the consent for this person that he wants this ligation to be done. Subsequently, what had happened on the very first occasion, my lord would kindly see is annexure P1 from page 19 onwards. Page number 21 is that relevant part wherein in that portion he had said ligation korate chai na. This form was never accepted by the hospital authorities, but after lodging several complaints, the health department comes up with this. My lord, kindly comes at page 43. Wherein they say that I have given my left hand thumb impression and I have given my consent, which is absolutely out and out of false statement, and I seek your lordship's kind intervention. I want this to be investigated thoroughly because this cannot sustain. I had never given a consent for this tubal ligation of my wife, and without my consent it was obtained, and now they say that the LTI is of mine.
At page, which page?
Page 43.
Who has done this inquiry, which is mentioned there at page 43?
But this order is signed by the CMOH inquiry report. Complaint of this inquiry report was also not served upon me. Now this order was passed without serving that inquiry report also.
Where is your complaint?
My complaint, there are several complaints, my lord, starting from page 22, annexure P2, page 23. Page 24, annexure P3 is also one of those inquiry that was constituted by that concerned hospital, and they also came to a conclusion that I say categorically that I had given no consent. And I have that particular form wherein I said that I don't want to give a consent, and that form was never accepted from me. I am ready and agreeable if there is a thorough investigation. I want an investigation to occur, but this cannot be done. At the hands of the state, they cannot say such false statements. I am not an illiterate person who would just give a LTI thumb impression. I am a person who signs, and there are representations also. Kindly sees my representations, all representations. I have signed myself. My signature is there. Why should I put an LTI?
All right.
My lord, so far this report is concerned, the final inquiry report was done in 5/10/2023. And if it is lordship takes that page, my lord, his consent. Now he cannot say that I have not given consent. Whimsically, it cannot be done, my lord. Kindly see page last annexure, my lord.
Page 43.
Page 43, my lord. Kindly see in connection with the subject and reference cited above, the undersigned is sending here with the inquiry report with the conclusion that the consent that the inquiry report has already been handed over to the petitioner.
No, the petitioner says he has not been
handed over the inquiry.
Cannot be, my lord. How he has procured this document and this is the document, my lord.
So this is something which was served upon me. That's why I rely on it. My lord, without going into much arguments, I say I am the person. They say that I have given my LTI. Let there be an investigation why the state is afraid of.
No, my lord, I am not afraid of. The question is, my lord, that is a dispute. The disputed question of law and facts. The thumb impression, he says that is not of mine. Now, my lord, CMOH will decide that whether
this is a case of forgery.
Yes.
Why don't you lodge an FIR?
But until and unless there is a conclusion to that effect that there is a forgery, we cannot.
No, you will lodge an FIR saying that it has been forged.
My lord, FIR against the CMOH and police, how my lord would kindly consider. What I want is, I want nothing. Let there be an appropriate inquiry by one of those, as your lordship may, my lord, deem fit and proper under the supervision of this honorable court. Question of a LTI. State has every mechanism. There's a QED department belonging to the
Complaint
CID.
has to be lodged from your end first. Approaching the High Court directly will not serve the purpose. You lodge a complaint. If the complaint is not acted upon, in that case, High Court will take stock of the matter. Directly approaching the High Court, I don't think will be proper, because then in that case, anybody can come and say that.
My lord, see, there's my representation at page 33. Addressed to the additional director, wherein I had said this. They wanted to show the false thumb impression of mine and my wife. I have stated that. I have made representations to that effect.
But what has fallen from his lordship, there is no such specific complaint to that effect.
Yes, it's there.
It should be, my lord, if he is disputing his thumb impression, my lord, then there should be an FIR.
You lodge an FIR. Why are you not lodging an FIR? Because if somebody's thumb impression, if this is a case of identity theft, somebody's identity has been stolen in this way. My signature has been forged, or someone else's thumb impression is being projected as my thumb impression.
But a government report will always be relied upon, because I have nothing to show, because on what basis I will be lodging the complaint. I, in fact, do not have that document also with me.
The problem is
that
cause of action is arose in 2021.
That's right, but why don't you supply the inquiry report to
that
the
inquiry
report, and also that no.
In connection, undersigned is sending here with the inquiry report with the conclusion that the consent has been given by Santosh Karmakar, husband of the first two lines, my lord, of page 43.
It doesn't show that the inquiry report is also supplied to him.
Yes.
The letter, kindly see the letter which has been, it's said copy forwarded for kind information. Copy of this letter has been forwarded to him for information that the inquiry report has gone from the CMOH to the person addressed in the letter dated 27th of August 2024. But he is entitled to the inquiry report.
Inquiry report and also
According to my instruction, my lord, according to my instruction, my lord,
one thing, I lodge a complaint. Now, my lord, under the relevant provision, earlier it was 91 CRPC, police will issue me a notice showing that on what basis you are saying that. I do not have the document in my hand to show that the thumb impression is this. So I won't be able to rely on those until and unless your lordships directs for an impartial investigation. This cannot be done. And this is something which is not a very, well, not a very minor thing. This is a forgery at the instance of the person sitting at the helm of affairs of the state government.
It is very easy to say all this, my lord.
I, at my own risk and peril, say
Why
that
he is silent, my lord, from 2021
I am
to
agreeable and
2024.
ready to face
For
the
3 years,
investigation.
my lord, he is waiting.
Why the state is afraid of? I am
There is no question of any apprehension or afraid of, my lord. The only things is, my lord, if he is so sure, my lord, that he has not given the, this is the stand that has been given by him, my lord.
Supply the inquiry report to
I shall
him,
supply.
and thereafter he'll take steps. Get the inquiry report, then lodge a complaint.
My inquiry report along with that, my lord, because kindly considers, my lord, this is prima facie. A report comes up from the CMO saying that that is my thumb impression. My lord, we cannot, my lord, go into disputing all these facts until and unless there is an order coming from your lordship. The difficulty is that, my lord, kindly visualize the situation. I am a person, a common citizen. I, at my own risk and peril, my lord, if I say something wrong, if the investigation under the supervision of this honorable court, I will be facing the heat of the consequences. I am ready and agreeable to
The
do
other
that.
person will see it. It will not be very easy for the court to disbelieve this chief medical officer
Lordship.
or others who have conducted the inquiry. The moment I say that I will disbelieve this merely because somebody poses a question, it will be too big a thing for the court to
Malad,
say
kindly,
immediately.
kindly
Because-
takes up this letter at page 33, addressed to the additional director, personal special secretary, wherein I had specifically agitated my grievance pursuant to the same. What did the additional director, personal, Malad would kindly directs this person based on this representation to take appropriate steps. That would also suffice my purpose.
That can be done. That can be.
With giving me a reasonable opportunity of hearing and all, Malad.
The writ petitioner. $64.
64 मतलब drawing for the petition मतलब इसमें affidavit of service. Well, serve copies to all the respondents. The petitioner मतलब before your lordship, the inaction by the respondent authorities मतलब for non-consideration of his representation for removing the illegal encroachment in the highway.
You want consideration of representation?
Yes, my lord, there is in my lord, kindly see my lord, page 47 once. This is a my lord, it's an email from the my lord, the SDO Malda. He said that my lord, a case may be filed before the SDA after my representation. And my lord, kindly see page.
What is SDEM?
Subdivisional Executive Magistrate. You will kindly see page 51. In addition to that. They said, my lord, whether the land belongs to PWD. If yes, then cause an inquiry and submit a comprehensive report in this department to in this regard to this department. Well, I don't know whether any report was filed before the deputy secretary or not. They took some action, my lord, till date, but thereafter they are totally silent over the issue. But it's a busy road, my lord. Kaliachak to my lord Niyamatpur.
Yes, sir. You are appearing for all the respondents.
Yes, my lord. My lord, I am.
There is a private respondent also.
Yes.
Yes, only I served the copy, only they received the copy.
They have received.
Yes, yes.
Please mark it. Which page? If you mark
My lord, I am drawing your lordship attention, my lord, regarding page number 7.
Page 7.
Yes, my lord. Paragraph 7. The cause of action arose, my lord, in the year 2013, as indicated in this paragraph, my lord. And this, my lord, 2025.
Trespass, it's a continuing cause of action.
My lord, whether belongs to the land,
Section 8 and
to the
section 10, my lord,
PWD or
said
not.
so.
Trespass is continuing cause of action.
Yes, my lord, that is correct, my lord. Representation may be considered, my lord, in accordance with law.
No, representation has been considered. They are acting on it, but he wants the action to be expedited.
Yes, my lord.
I'm expediting it.
Oh, double eight.
Private respondents has been served. Can
Yes, my lord, served.
Kindly mark them.
My lord, inquiry is required, my lord, whether land
Yes,
belongs
you do your inquiry, you do it quickly. That
Yes,
is
my lord.
all that he wants.
If belongs to the PWD, then action shall be taken.
Yes, that is your, you see
Yes,
page 51.
Yes, my lord. Yes,
But
ma'am.
in service,
I
my lord,
attend, ma'am.
kindly see page 8 and page 17, 18 and 19.
Nenin. ও 6 উইকসটাকে 8 উইকস করে দিন না, হিয়ারিং টিয়ারিং দিয়ে অনেক টাইম লাগবে। 8 উইকস।
Right. May I please your lordship of the petitioner, my lord? This is my evidence to service, my lord. Now, my lord, in this matter, I have applied before the BL respondent number 4, the BL and LRO, under the RTI Act for the certified copy of some khatiyans. And the paragraph number 1 says khatiyan number 4181, 200, 200, 2895 and 3382 RS khatiyans. Now, my lord, what happened? If your lordship kindly comes to page number 9 of my writ petition, my lord will see that with respect to my application of khatiyan number 4181, the BLRO has remarked nay in Bengali, my lord. Kindly see page number 9. The BL and LRO in their Montobbo column has remarked nay. And then, my lord, again in page number page.
I couldn't get it.
My lord, this is the application before the BL and LRO on the RTIR for certified copy. Now, my lord, in the Montobbo column, there is a nay.
Acha, this slanting one.
This slanting one, there is a nay. And now, my lord, the next page, there was no remark from the BL and LRO. And the page number 11, if your lordship kindly sees, this is very important, my lord. This is khatiyan number 2895. My lord, kindly note the khatiyan number. This is khatiyan number 2895. My lord will get in the last portion, Bhumi Toposhil, then Jela Mendipur, there is this khatiyan number 2895 in Bengali, my lord.
2895.
2895. And then, my lord, it is marked as cross. So, my lord, this is also not available to BL and LRO according to BL and LRO. Now, my lord, what I did, I went on an appeal before the appellate authority. My lord will find the order of the appellate authority in page number 19. Now, the final order is order number 3, wherein the appellate authority says
directed to give you.
They have directed to give me, my lord. Now, my lord, after that, by a communication page number 20, my lord, they have given me only the certified copy of khatiyan number 2895, which they have marked with a cross. Now, my lord, kindly comes back to the page number 11 of my writ petition, 2895. They have earlier marked it with a cross. And now they are page number 11 of my writ petition, my lord. They had earlier marked it with a cross. And now they have given me that 2895 khatiyan. And now they are saying that the rest of the khatiyans are not available with me.
You have served the respondents.
My lord, I have served the respondents, my lord. This is my evidence of service, my lord. The only state is answering respondent, my lord.
Serve a notice again. Come back on Friday.
Well, some precedents will be given in this matter, my lord.
Yes, all matters on Friday will be under a fixed heading.
My lord. My lord will give order.
ওই অর্ডারটাই রেকর্ড করে নি।
$66 million I beg to appear for the petitioner. Do I have served? Not everybody has received.
And
Oh,
for the
yes.
state.
Yes. She has come. But before entering into the interim of my writ petition and the prayers thereof, Lord, may I just, Lord, indicate, Lord, the very short facts. Lord, here, the petitioner before your lordship has obtained a loan from the non-banking financial corporation to the tune of rupees 15 lakhs by mortgaging his land measuring about 7 satak. In that land, there was no building, Danga land. What has happened, Lord, he has failed to repay. He has, Lord, submitted, Lord, several, Lord, representations regarding, Lord, one-time settlement that my business has gone down. I can only pay 10 lakhs. kindly accept this. Lord, the non-banking financial institution, Lord, did not accede to that. Since there was no no settlement between the parties, Milord, what they did, Milord, the non-banking financial institution, which is the party here, Milord, the officials of non-banking financial corporation, Milord, has come to the residence of the prisoners and Milord trying to disturb their position, deciding, and along with the all members, elder members are there. Day after day, Milord, they have come in the house. In that event, they set, or rather threatened, with the help of the local police authorities, by showing that they have the DM order, they will evict the petitioners and his family members from their residence. Though the land with the residents were not the mortgage property, and there was no certificate issued by any tribunal saying that this is the property of the petitioner. So that property was attached by any tribunal or something like that. There is no. So, my lord, lastly, the petitioner before your lordship, my lord, told the financial institution that you sell out my property, which was mortgaged to them. The non-banking financial commission did not do that. Once upon a time, what he has done, the non-banking financial company, my lord, with the help of the police authorities, Lord, came to the residence of the petitioners and thrown away from his residence and put under the lock and key. They went out from the rooms. They are here and there. Before that, Lord, since they are coming to the house of the petitioners, Lord, the petitioners was constant to file a suit that this is the mortgage property. They should not disturb their position with regard to the living and with regard to the premises. Lord, that in that suit, the competent civil court has passed an order of status quo. Not status quo, restraining the financial institutions not to disturb the peaceful position of the petitioner. In spite of that suit and the existing of this order, Lord, they have come and thrown away the petitioners and his family members from their residence. Lord, thereafter we made the complaint again to the DM. They have not shown to the DM order. They have not shown to the police, not the order of the police, but police authorities have came and with the help of the police authorities, they have thrown away the petitioner. After 3 or 4 days, it is open that by entire buildings, the lock and key had been broken. There is nothing, and all the household properties were gone away here and there, and there is none. We enter into the premises, and thereafter we had again complained. Nothing has been done. At the present moment, their entire action is illegal because the land which was not mortgaged with the financial the company are not the mortgage property, but they have done illegally by throwing out, by losing all our properties lying at the premises. I pray for compensation.
But how Writ Court will grant compensation?
Writ Court, your lordship knows, there are several orders passed by the Honorable Supreme Court.
First of all, this question itself will have to be decided which property is mortgaged, which property.
That I am told to lordship from the documents itself.
By the documents only, it will not be clear because it is a disputed question of fact again.
It will be clear from the 13 to notice. If I show to lordship 13 to notice.
13 to notice will indicate which property it is. Now the property where.
Right. And the documents which I have also annexed here. Which document is the
who is appearing for the financial corporation?
I have served. Notice has been given.
Because compensation in any case, the amount of compensation, all
entire illegal action against me.
Even then, all these things cannot be gone into by a Writ Court. How compensation will be determined by a Writ Court? What will be the standard? What will be the basis for judging the compensation? How Writ Court will? Evidence will have to be adduced. Value of land, value of what is what is the extent of loss?
I am not asking any
extent of loss that you have suffered.
I am not asking the value of the land. Land is with
I understand. What is the extent of loss that you have suffered? That has to be assessed.
Entire household properties.
Very well. What is the extent? Entire household properties, I cannot assess. It has to be assessed on the basis of some kind of evidence. How will it be decided in a summary proceeding?
In summary proceeding, in Writ Court, since your lordship has the white power.
I understand the power, but on the basis of affidavit evidence, How will I assess as to what is the extent of damage that has been caused, which can be compensated in terms of money?
I have stated in my petition.
That is your statement.
Yes.
That is
That
your
is
statement.
absolutely my
I have
statement.
to reach a conclusion. I will
Absolutely.
have to reach a conclusion upon getting their statement.
Right.
Statement versus statement will lead me nowhere. I will have to take evidence then. What is the value? Somebody, some expert being appointed.
I have understood your lordship. What is foreign from your lordship? What is foreign from your lordship? I have understood. But questions is two things. One is whether the authorities had done any illegal action or not. This is one thing. Whether I am be able to satisfy your lordship that the land which was not mortgaged, my lord, but they have disturbed me by damaging my goods, that I can assure to your lordship from this petition itself.
You say I can admit the petition because at this stage I cannot grant any interim relief.
Let them file the affidavit in this. Let them file the affidavit. Thereby, your lordship will decide. So, for the compensation is concerned, your lordship can do that.
No,
whatever the compensation is that.
I will be keeping the
only I have to.
I have keeping the entertainability issue open, and I will direct
Petitioner
filing
has
of
already
affidavit.
filed civil suit, my lord.
No,
The entire allegation against the
There was no damage. No damage was claimed there. They are only injunction. Injunction that
You can claim damages there also. You can amend
that
your
should I cannot claim.
Why not amend your plan? Why you cannot claim?
In that should is for only declaration and injunction.
You
And
amend your
injunction has been granted.
You can amend it because there is a subsequent cause of action. It will avoid multiplicity of suits. You can always amend your suit and insert your prayers, because in any case you would have to approach the civil court according to this court's view.
Your lordship knows about the practice of the law.
The High Court sitting in writ jurisdiction would not have the wherewithal to assess the extent of damages caused and the compensation to be paid, because I can keep it pending. Your petitioner will languish unnecessarily. When affidavits will be filed, when this matter will be heard, and ultimately you will end up getting an order of dismissal for non-maintainability, because compensation, I have serious doubts.
Lord, I have also said to some judgments of the Honorable Supreme Court where
very rare, where there is no dispute as regards quantum. If there is an admitted amount, then in that case it can be done. Writ court, difficult, very difficult, near to impossible. I can admit it, keeping the maintainability open, but that will not serve any purpose. Actually, your remedy will be civil. It's a civil remedy. It's a tort, civil wrong.
What civil at the same time, Lord, they have violated their.
All of this can be gone into by the civil code, because this aspect,
duties and obligations, vested upon them under the statute have been violated here.
Yes, that is there.
Not only the civil wrong.
But mere declaration will not do. You need compensation also. Who will assess that? The extent of damages caused. Writ court will give you on the basis of some
wrong action undertaken by the authorities.
Quantum, sir, quantum.
Quantum, your lordship has the power, whatever, whether it should be 5 lakhs or it should be 1 lakh, or should be 50,000.
It cannot be exercised in vacuum. What is the extent of loss caused has to be ascertained. Extent of loss caused has to be ascertained.
I can try your lordships to assist on that aspect also. Obviously, after filing affidavits, I want to know their stand also. Anyhow, if your lordship will kindly give liberty to amend my plain there.
Liberty in a writ court, how will I grant you liberty to amend your civil suit?
No. I can raise the point before that court.
You are withdrawing this.
Then in that event, I will withdraw it.
In court. Give. I'm grateful to you.
नाम दिलम
Seven. This matter, my lord, I am appearing from the Union on behalf of Union of India, my lord. We have not yet received the instruction, my lord.
Who is the effective respondent? Union of India.
Effective, my lord. All are effective, my lord. 3 and 4 are received, my lord.
3 and 4 are?
Have received them.
No, who are 3 and 4?
3 is the General Manager, Ministry of Defence.
Oh, that means Union of India is the effective respondent.
And 4
When
is the
do you
Joint
want-
General Secretary.
My lord, Ordinance Factory. I think, my lord, they are having separate panel, my lord. I don't know, my lord.
Then not today. Let us see. Let it.
Tender matter, my lord.
Lordship, Ms. Sushmita Shahadatti is appearing for the respondents. She has not come
Response number?
to Union of India.
I am also for Union of India.
Union of India.
Then, my lord, she must be appearing on behalf of the.
My lord, keep
Will be able to come tomorrow.
Make it not this week, man.
Not today.
Not this week.
My lord, only
this
not
week.
today.
Not today.
Not today, because
Not-
tender matter, my
not
lord,
this week.
pending from November, my lord.
Let him try
And
his
work
luck.
order is for 1
Not
year.
today.
Not today, my lord. But tomorrow it will remain in position.
Yes, yes, it will remain in.
My lord. Much obliged.
67, I was not able to join as a panelist, Your Lordship. 67 for the Union of India, Your Lordship.
67 has been made not today, madam.
I'm so grateful. I'm grateful to Your Lordship.
68, we are appearing for the state.
I am for the petitioner. May I please your lordship, my lord, this is my service. Before my lord opening the petition, I am showing my lord some annexures. Kindly come to page 17, annexure P1.
Yes.
My lord, it is a demand notice issued on 22nd August 2020. Then I have made the payment of the demand on 14th September 2020. Page 18. Now, lordship, kindly come to page 20. Deed of license.
20.
Between me and the governor of the West Bengal.
Yes.
Now, kindly come to my lord, page 2020.
Page?
22.
22.
Clause 1.
Yes.
My place that the first party dot hereby grant permission and or liberty to the second party to use the licensed premises free from all encumbrances as mentioned in Schedule B herein.
There is a renewal clause. Got
Yes,
it.
and they said that license will be done as per
Mutual
renewal of the license will be done as per mutual discussion between the licensor and licensee. Now kindly see my lord the Schedule B. Schedule B, my lord, page 24.
Page 24, Schedule B.
Schedule B, that Schedule B was given to me for conducting my business. Now kindly come to my lord, page 26.
Page 26.
They have issued the notice to me April 26, 2023. Sir, with reference to the subject site above, it is hereby informed you that these authorities shall consider renewal permission, parking plaza in front of Junction Mall City Center, subject to payment of license fees as mentioned below. That is, they have given the notice and they have issued me the bill on 12th July 12, page 38. Two bills. two demand notice. One is rupees 18,74,000.
38.
30A, capital A.
TA. 30A, yes.
Amount, my lord, the date of issue of demand notice, my lord, that is July 12, 2023. And amount was 18,74,321. On the same day, they have issued another demand notice. Next page, 30B. This amount was 17,03,928. Now I have paid. Kindly come to Malad 30C and 30D. 30C 20th July 2023. After 7 days, I have paid 18,74,322.
30C.
30C.
Yes.
And then next page, on the same day, July 2023, I paid 17,03,929. They received. Now I'll kindly consider clause 1, that is page 2022. Page 22.
Yes.
They have made confirmation. Clause 2022, kindly see, renewals of the license, renewals of the term of license will be done as per mutual discussion between the licensee and licensee on or before the expiry of the term license. That means it was executed on 13th day of November 2020. Now I have issued notice within the period, that is, kindly come to my page 27. As per the subject and reference specified above, we hereby request yourself for renewal of existing license on mutual discussion as per clause number 1 in deed of license dated 13/11/2020 for parking plaza kiosks holding pay use toilets of opposite Junction Mall, City Center, Durgapur. They received on, my lord, kindly see, 30th October 2023. That is the within the expiry of the license. Moreover, they have issued demand notice on July 2023. Within July 2023, with the observation that
where is the demand notice?
The demand notice is, my lord,
30A.
30A and 30B. Firstly, my lord, in the clause 1 of the license deed, they said it shall be renewal on or before the date under mutual consideration. Secondly, they have said April 26, 2023, page 26, giving two demand notice and say authority shall consider renewal permission even thereafter, my lord, 30th October 2023, I have made a good many representations. They have not considered. But what they have done, my lord, kindly see, they have published an e-auction notice.
Page. And what happened to the money that you had deposited?
They have accepted. 3 years, my lord, 3 years, 3 demand notice. We already paid. But question is this for renewal. Last two demand notice, my lord, they said we shall consider
What was the tenure of the license?
3 years.
3 years.
Yes.
Where do I get it?
Page 22, my lord.
Page?
Page
22.
22,
22.
my lord. Clause 1.
3 years.
Yes.
And this license was to expire on?
Expire on, my lord, 12 of
That is
12
November
12 November 2023. I am still in possession. When they have commented, they commit that we shall renew the license subject to the payment of 2 demand justice. I already paid without giving notice, without my disposal of my representations. How they can issue the e-auction notice? 3rd October 2024.
No. The document at page 26.
Yes.
Where the amounts have been asked for.
Yes.
These amounts are for periods prior to during the subsistence.
For 3 years. For 3 years, 3 payment.
These are, one is for 13th of September 2021 to 12th September 2022. Another is for 13th September 2022 to 12th September 2023.
Yes.
So this is within 3 years only.
Within 3 years only.
Not beyond that.
Not beyond that, because they have not issued me any demand notice. What is happening, my lord? They have the messenger.
The extension or renewal will be done only on mutual discussion.
I have made several representations. They have not disposed of. They have not followed the doctrine of principle natural justice.
So mutual discussion, if they have not done, how can I compel them to enter into a discussion by way of a writ petition?
Malad, may I submit to lordship? Malad, they are under Article 12. ADDA.
That is there,
Malad,
but
then,
they have.
Then, my lord, they have to state, they have to statutory duty on good faith. I have given so many contracts. I have given so many representations.
There is no statutory duty involved here. This is a contract that if we renew, we will renew if we reach a consensus on mutual discussion.
But when they have said, that we shall renew, agreement says.
It doesn't say we shall renew. It says that
kindly come to my lord. Kindly come.
It says it will consider renewal permission. Consider does not mean that it will give an answer in the affirmative.
Then if they shall not consider this, it is their duty to deny of that.
They might have considered and not permitted.
But when they say authority shall consider, then it is the duty, obligatory duty. Because they are the state. Even they have to maintain chapter 4, directive principles. They have to show, they have to.
Very well. Yes, sir. What is your answer?
My lord, some instruction is required, my lord, in this matter. First of all, my lord,
But if you have given him to understand that you will consider the renewal upon payment of the fees and he has deposited the fees, then you ought to have considered it one way or the other, saying that yes, we accede to the renewal proposal or we do not accede to the renewal proposal. He has made representations.
Can you send the representation before the concerned authority, my lord, who will consider
But
this?
in the meantime, you have already
published
an auction. That means that you have not considered the representation.
So I am saying before lordship, kindly one instruction is required in this matter, because the auction notice has been published. Due to
Let them file a little bit in the meantime stay of the auction notice.
No, auction I will not stay.
Then I have
the whole work will be stayed unnecessarily. Auction I can't stay. How soon can you come back with instructions? Because this is an auction of 3rd of October 2024. We are already 6 months down the line from the date when the auction was made. If it was 1 week, 2 weeks, then in that case I would have considered granting an interim order. But at this distance in time, granting of
but my lord, I submit to lordship, my lord, when they have published, before of that date, even my lord, I have represented.
That I understand, but your writ has been pending since October 2024. You could have mentioned it and got it heard if it was so urgent. But now, interim order, I don't think there is any scope now.
Otherwise, my lord, may I submit to lordship, my lord, I have invested in havoc amount, course of amount, 55% having that conducting the deliberate from my premises.
When is the
55.
date of the auction?
My lord, they have not said so. They have issued this notice, my lord, on 3rd of October.
No, they have given auction date is 19th of November. Auction is complete.
No auction was complete, my lord.
Yes, first page 32. There is a chart given. See the last item. Auction end date 19/11/2024. Auction start date.
But there is no auction happened.
Yes, sir. What is your instruction on this? No instruction.
I have no instruction at this moment. So 2 weeks time is required, my lord, in this matter, because without any instruction, not possible to say anything. The auction notice has been completed or not.
My lord, only my lord pay for protection. Only I am praying, my lord, they shall not disturb my business.
They have not yet disturbed. If they disturb, you come back. I'm not refusing interim order. I'm giving him time to For 2 weeks time, I've given 2 weeks.
Deeply obliged.
আপনার যদি কেউ থাকে করে দেবেন। হ্যাঁ, দেখে যান।
Sixty-nine.
69. I am on behalf of petitioner, I pray for time.
Not today.
Not today.
17.
If both sides are here, I'll take it.
I'm for the Union of India.
Then notice under
Ranjit Kumar Sinha, my lord. Happiness of the Union of India. Ranjit Kumar Sinha. He has not come today. I think not today, my lord.
He has not come to court.
No, my lord.
Tomorrow.
Tomorrow.
Sinha is appearing against me in court room number 37 just now. Oh, that was Ranujit.
No, not him. Yourselves.
Tomorrow, Mr. Banerjee.
Tomorrow, my lord. Tomorrow.
Grateful.
71.
My lord, I am appearing on the behalf of the petitioner, my lord.
My lord, I am appearing for the respondents.
My lord, the petitioner was allotted the.
71.
My lord, I am very.
I am appearing for this.
Good. Somebody is there.
Lord, very simple facts, my lord, not complicated at all. But there is some complication. I'll come to that bit, my lord, later. First is, my lord, there is an information that I seek before the post office, which is the India Post. My father dies, my lord. There is a post office account that my father had. There were certain monies that were lying. My mother was the nominee of the account. There are 2 other siblings that I have. 3 of us are the legal heirs. Mother also passes away in the interregnum period. I do not know about the account or the money or whatever is held in that post office account. I make an RTI application under section 6 of the RTI Act. That gets rejected under on the basis of section 8J, saying that this is in the nature of a person. This is in the nature of a personal information. This cannot be given. So by that order, my application gets rejected. I go under section 19 by way of a first appeal, saying that this is not maintainable because this account, now that I have become a legal heir upon the death, because this is by operation of law, I would be entitled to this information. I do all of this on the basis of an heirship certificate that I disclose. That first appeal also gets dismissed against me on the same ground. Absolutely cyclostide order. Nothing which is reasoned with respect to my application and the points that I take in the first appeal, not dealt with at all. Basically a cut copy paste of the original order that is passed. So against that, my lord, now this is where it gets slightly complicated, and I'll not, my lord, hold it back. I'll be very candid. I prefer a second appeal from that. Now that second appeal, which is statutory appeal, that is pending before the authority. Simultaneously, I assail the original order and the first appellate order, which is already pending before the second appeal, which is coming before this court. Now, I understand the first hurdle that'll be in front of me, that'll face me, is that because I've already gone before the second appellate authority, then I will.
The appellate authority has decided or not?
Not decided, it's pending.
I'm directing them to decide it.
Expeditiously.
Yes.
Well, the only difficult.
The purpose, because 2 proceedings in respect of the same order.
One before the writ court and the other before the second appellate court.
And they are the statutorily recognized forum. So let them decide it.
My lord, the thing is not so.
Just act a line. My only objection to that was this, or not objection. I'm just making this prayer that because it's an alternative remedy, I am willing to have taken instruction. I am willing to withdraw the second appeal by making a representation. If this court permits me.
That won't be proper, because see, that is a statutory remedy. You have availed of that.
Yes.
For the purpose of taking benefit of a writ remedy, you will withdraw the statutory remedy. That won't look.
Only in as much as it's no longer efficacious to me. I filed that sometime in the month of August.
So what?
Alternative, yes, because it's statutory.
It is pending.
But since August, they haven't.
They'll take a decision. We'll direct them.
For expeditious disposal of.
My lord, the thing is not so simple as it is stated. The person who has died, his name was Aurobindo Pal. Kindly see the cause title. Kindly see the cause title. I shall come to other documents later. How a dubious method has been adopted.
Yes.
Monimoy Pal, son of late Arindam Pal. not Aurobindo Pal. Kindly come to page 18, the affidavit. I shall be requesting your lordship that this executive magistrate should be called on at the dock. I, Monimoy Pal, son of late Arindam Pal. Thereafter, the next page, that my father Aurobindo Pal. What is going on? I am asking this question to myself. How can this executive magistrate affirm this affidavit? How can this executive magistrate affirm this affidavit? He is not seen the affidavit and he has affirmed it. He is doing a clerical job, nothing else. And kindly come to paragraph 5, page 4. Legal heirs are they named, his name is not there. Paragraph 5, page 4. I am praying for an investigation, my lord. Some foul play is going on. Monimoy Pal's name is not there in the legal heirs. Along with paragraph 18, his own affidavit says he is a son of Arindam Pal. His cause title says he is a son of Arindam Pal. And now he is seeking information of somebody else, Aurobindo Pal. So why shall we give him? And this executive magistrate should be penalized, my lord. At least he should be called on and I shall examine him on dock, this executive magistrate.
No, this is serious. He's absolutely right. This I'm told my instruction is that this is a typographical
No, there are 3 documents.
The typographical mistake
simultaneously cannot be typographical error.
Mistake. I'll be very candid. Well, I have drafted the writ application. The cause title has been put by me. It's not on the instruction of the client. I take personal liability for this. I have drafted the cause title based on the affidavit that was affirmed, because this was the document that was lying.
The affidavit is a questionable document.
So this is the document. The writ application is drafted by me. The drafting is based on the affidavit which is appearing at page number 18, shown by my learned senior friend. Now, what could possibly be a typographical mistake?
What he's saying is a typographical mistake.
What appears to be a typo, and I'm saying appear because I'm taking a bit of caution when I make this submission. What appears to be a typographical mistake is at page 18, first page. I am told that what is appearing at page number 19, paragraph 1, Shri Aurobindo Pal, that is the name of the father, my learned senior friend, is absolutely correct. What has gone down at page number 18 is a typographical mistake which is possibly attributable to an advocate who has drafted this. Naturally, the client has not drafted it. This has gone before the executive. I'm not defending the authority, the executive magistrate.
Now, kindly come to,
have looked at this paper.
Kindly come to paragraph 6 of the writ petition. He is saying it's a typographical error. He has drafted. He is taking his responsibility on his own. But what about paragraph 6, where he says the father, his name is Aurobindo Pal, father of the petitioner?
Yes, this is the
there he is correct. But when I point out the mistake, there he says it's a typographical error. These two, paragraph 5 and 6, are not telling.
Correct. He's right.
This is not a typographical error. This is some foul play is going on. And the executive magistrate should be called on before the dock.
Not with respect to the writ petition. Advocate record has possibly corrected 6, overlooked the cause title.
This is not a case of mere overlooking. This cannot be. There are some multiple documents where Arindam Pal's name is there.
Lordship looks at page number 15 of the affidavit once more. Affidavit to the writ application.
Affidavit says Aurobindo Pal.
That's the affidavit to the writ application.
Affidavit says Aurobindo Pal.
This is an educated person, 45 years of age. He's drafted this. I mean, he's affirmed this. The page that really matters in a writ proceeding is page.
Now, how can the executive magistrate affidavit can be relied on by him? He is himself relying on the document.
There's no foul play.
Let him rectify that.
I'm a son is an undisputed. There's no other legal heir who's
let him go to the civil court and let him go to the civil court and make a declaration. Come with a declaration.
Sister has not come forward and said that I'm not their sibling. Today and also the cause of action, the rejection is on the ground that it's personal information.
And paragraph
the authority does not take into account any of these apparent
identity card.
Paragraph 5 he himself says that there are other legal heirs.
Think that if he has an identity card where the name is Aurobindo Pal, then
well, kindly see paragraph 5. Paragraph 5 of the writ petition. With the name of the heirs are there. His name is nowhere. He himself says that.
This is slightly. With the greatest of respect, I understand what he's saying. definitely something which is worth looking at and for the judicial scrutiny. But probably I say this with a little bit of responsibility, probably blown out of proportion. There's a mistake, there's a confusion which is attributable to lawyers. I am putting my neck out and saying that possibly attributable to me also. As an
Ultimate
individual.
responsibilities of the client. Lawyer cannot take
He has not
extend his rope to take the responsibility.
Lordship knows how these are filed. This is also, my lord, something that we have to be cognizant of. But that is not the
Client
ground.
has affirmed the affidavit. Client has given him the documents.
It's not the
You
ground.
bring
I will
your
bring it, my lord. I'll bring it
identity
tomorrow itself.
Which bears your father's name tomorrow?
Aadhaar card, Xerox code and I'll bring it tomorrow itself. Is it a lordship's pleasure that we'll bring it by way of an affidavit, or we'll just bring it, hand it up to the court? I think that will also do.
Form an affidavit tomorrow. Let it.
Tomorrow, my lord, we'll not be able to.
Day after tomorrow.
Day after tomorrow,
Lordship
then
is
I will kindly
sitting-
keep it at 2 p.m. First, how I have a matter fixed in code number 24. Second appeal matter.
29th. No, may I say this? Lordship keeps it tomorrow. May I just hand up the document? I'll ask my client
No,
to.
I'll have to take it formally on record, na.
Day after tomorrow at 2 p.m. Then Lordship, that 20. Your Lordship is sitting till the 29th.
28th.
28th, which is
Day after tomorrow.
very well. Lordship keeps it at any time, my lord.
My lord, today he is taking such plea, and his client knows everything. His client has affirmed the affidavit.
The actual thing is that we have to arrive at the truth, not to beat on technicalities. We all make mistakes.
Well, this
if
is not a
something
technicality. The affidavit says otherwise.
His father's name is really Aurobindo Pal.
Then where will the affidavit stand?
No,
He
if
is
the
relying
identity
on.
card says, then what would you say? Would you say that it is a mistake, or would you go and hang him saying that why has made a mistake here?
My lord,
That
these
is not the-
unique identification cards, how these are made today, my lord knows.
Similarly, typos are also.
This is
there
not a
everywhere.
typography. There are three situations.
Let's not make a fuss.
But
of
on a slightly lighter note, my lord, this is one of those. There's the movie, my lord, Hindi movie, where this person who's been declared to be dead comes before the court. The court asks, "Give me evidence that you're alive," because there's no document. It's Jolly LLB, my lord. This is exactly one of the. He's his son. There's a typographical error on record.
card, you bring your I
We'll
card,
bring
I
the
have a
identity card. We'll
supplementary
bring it by way of a supplementary affidavit.
Supplementary.
My lord, only one thing, my lord, 28th, kindly keep it at 2 p.m. my
I
lord.
don't have a difficult.
If
At
you
your
need the
lordship's
list,
pleasure.
Well,
if you are not
first
there,
half I will not
if you are
be
not
there.
there, ask your junior to take time.
My lord, my lord.
It will be taken up at
My lord.
20th.
May I pray for an order? I am
Lordship,
representing
I am
authority.
this I agree with my lord. Something.
Affidavit of service.
Made a representation to consideration of this. They have considered the new cause of action arose that's why the application has been infractuous.
Do you have any letter or something of that sort?
No, they have communicated the reason.
We have
made
supplied the reason order to him.
reason order. They have supplied me.
What is your name?
Arunabha Ganguly.
You are the advocate
Yes,
on
my
record?
lord. I am the advocate on record. MD Kalimuddin, my lord, the 78. Kalimuddin, the Kalimuddin লেখা আছে। Kalimuddin, হ্যাঁ নামটাও বলে দিলাম তো।
নাম্বারটা বললাম 27841
27841 দেখে নিয়েছো they have communicated the reason. That's why the
advertisement have published.
You have a copy of the reason. At least put that on record.
I have a soft copy.
But the copy is with my
Then I'm
client.
putting it as for non-prosecution tomorrow.
Non-prosecution to be mentioned because the
To be mentioned.
because
It will
they have
appear as to be mentioned
yes,
tomorrow.
to be mentioned.
You bring that letter.
Grateful.
To be mentioned tomorrow.
Because but
78.
My lord, may be permitted to mention item number 77.
77?
Actually, my lord, I have been led by Mr. Rudra Prasad Sinha. He was there in court today, but sometimes he fell sick, so he went home. So he instructed me to take not this week.
Not this week. 77, not this.
Grateful.
I am making the similar pair in respect to item number 97, not this week.
97. Very well, not this.
I'm for the petitioner. Not this.
Any matter with both sides are there?
72, you are.
Both sides are there?
So, Lordship, I'm praying for not today. Not today.
Not today, it's already not today. It won't be called.